the system to be able to get there.
Ackerman. It's Ackerman. Yes. The reason why I'm raising that is because the transcript of the 4th of March is that of Advocate Anton Ackerman.
Yes, it is.
Yes.
I'm-
Okay.
I'm putting what
Yes.
Mr. Ackerman told the
Okay.
commission.
Thank you. I'm with you. And what page?
It is page 11.
Page 11.
Mr. Piccoli, Mr. Vani was asking Mr. Ackerman about the president's speech where the president was reporting after the handing over of the TRC records. And he was being asked what was his view about that speech. And it's quite a long extract. I do not want to read all of it. But the gravamen of what Mr. Ackerman was saying was that the president at the time was being Machiavellic. Some of us don't know the meaning of the word, but what he says is that Mr. Mbeki used to achieve this end, and this end was unconstitutional. It was morally questionable. This was the process embarked on by the amnesty team, the draft amnesty bill, and ultimately the amendments to the TRC prosecuting policy, which became effective on the 1st of December 2005. That amounted to a rerun of the amnesty process. But when you were asked, and you were asked a number of questions on this issue, you differ with Mr. Ackerman on this issue, that there was nothing wrong with the speech that was made or delivered by the president on that day to Parliament. You still stick to that?
Thanks, Council. Good morning, Chairperson and Commissioners. Yes, I still stand by what I said. Remember the time I was the DG of Justice.
And indeed, you were the DG between 1999 to 2005.
That is correct.
And Mr. Ackerman refers to this speech as Machiavellian and alleges that that means he used to achieve this end, the means that he used were unconstitutional, so was the end. You differ with that?
Yes, I've got my own position on the matter, which I've previously stated.
And you confirm that there was nothing mischievous about the speech that was delivered by President Mbeki?
No, I saw it, Commissioners, thank you. I saw it within the context of our history and where we were at that particular point in time in terms of achieving national unity and promoting reconciliation. So for me, it was still consistent with that.
And in fact, at page 40 of the 12th of March transcript, you say at page 40, line 24 to 41, in summary, I fully agreed with what the president said in 2003, having been a participant in those conflicts. And then you go on in that paragraph. Can I then take you to Mr. Ackerman's affidavit? The affidavit is at bundle 4. Bundle 2. And it is on, I don't know whether you have bundle.
It's the same one where he was questioned by Mr. Vani,
No.
which you have just quoted.
It is just an affidavit, it's not the transcript.
Oh.
His first affidavit. But you can go to bundle 4 at page 228, para 24.
Excuse me. There are too many banners in front of me.
Is this the Alata bundle form?
I beg your pardon?
Is this the Alata bundle form?
Yes, my apologies, it is. You're looking at the wrong bundle, I'm so sorry.
It's okay. Page?
It is page 228. Chair, you have,
Yes, we are with you.
Mr. Pickle, I don't know whether you have it. Again,
Yes, I'm
Mr.
to take.
Ackerman mentions that he was opposed to the amendments to the prosecution policy,
Which paragraph?
paragraph 24.
Yes.
This is what he says, I felt they violated the constitutional rights of the complainants and constituted unwarranted interference in the prosecutorial independence of the NPA. He again expresses his dissatisfaction, but you don't agree with that.
Pardon?
You do not agree with that formulation of his, that it was unconstitutional.
Well, I would say, in the end, he was proven correct because they were later, the amendments to the prosecution policy were declared invalid and unconstitutional.
But during the process that you were undertaking, you did not at that stage feel that these processes were a violation and they were unconstitutional.
Yes, I didn't have a problem with that because I thought it was a question of trying to accommodate the outstanding TRC matters which were not attended to during the life of the TRC. Therefore, a mechanism had to be found to deal with those outstanding matters. So I felt that for as long as they fall within the Constitution and the law, then there'd be nothing wrong in amending a prosecution policy.
Mr. Ackerman, in his affidavit, the 2005 affidavit, I think. Yeah, 2015 affidavit says that the first act of political interference, which effectively stopped the work of the PCLU into the TRC cases, was the suspension of such cases during 2004, and we will get to that. But what it is that you were doing while you were the DG and you were then also the Director General, the NDPP when you went over in 2005, was to work on this policy.
Well, 2004, I was the DG.
DG, yes.
2005, I became the NTPP. There was work that was being done on amending the prosecution policy, commissioners.
And according to you, that was not interfering with the work of the.
No, certainly. At that time, I didn't see anything wrong with that. I actually supported the process.
If we can then move, Mr. Piccoli, to the Nkadimen judgment. The Nkadimen judgment will be item 6, pages 14 to 49.
Is that in the same bundle?
It is. I do not.
Bundle 6.
Bundle. In your bundle, it will be under item 6. I'm sorry, I think you need to have somebody next to you helping
Yes,
you.
I do
really
need
am
assistance.
sorry. I may inquire, the commission has
Item
pages.
6
Item 6,
of the indexed,
bundle that you have in front of you.
Yes.
Then it is
so you're
page,
referring to the judgment.
the judgment.
Okay.
And I will refer to paragraph 15.4.4.1. My junior is going to try and help so that we expedite it. Paragraph 15.4.4.1.
Paragraph 15.4.1.
4.4.1.
Yes.
And it reads, I'm mindful of the first respondent's assertion that it was not, and it is still not, its intention not to prosecute where there
Sorry.
is where there is a strong case.
On 15.4?
4.1. How does that one read?
No. It says, remember, when Mr. Marcus. Okay.
Are you there?
Yes,
I'm mindful.
15.4.4.1.
I'm mindful
Yes.
of the first respondent's assertion that it was not, and it is still not, its intention not to prosecute where there is a strong case and adequate evidence to back up this prosecution. Surely this is understandable because the very existence of the first respondent is to prosecute crimes. The submission, as I understood it, is that there is no need for the applicants to panic. That might be so. However, the real issue, as I see it, is whether the policy amendments, which do not properly reflect the intention of the respondents, should be allowed to remain in the book. I did not think so. I do not think so. Then the judge goes on to say, at the risk of repetition, the applicants aver that it is not their case that the policy amendments expressly provide for an amnesty, indemnity, or a rerun of the TRC. Rather, that the application of the policy amendments in relation to a decision not to prosecute will have this effect. My question, Advocate Piccoli, would be, you agree that the amendments were not drafted with the intention of not prosecuting where there is a strong case and adequate evidence to back up the prosecution?
Yes, for as long as the NGPP still retained a discretion whether to prosecute or not to prosecute. And the amendments did not interfere with that discretion.
In fact, the applicant's case was not that the amendments expressly provided for the rerun of the cases, but that the policy amendments would have that effect. And that is what the judge is saying, that they do not say that the policy amendments expressly provide for that, but the consequence is that the policy would have that effect.
Well, I suppose it could.
But that there was no intention of the DOJ at the time to do a rerun.
Yeah, it takes me back to what I've always been saying, starting from the policy statement that was made by the President in Parliament in 2003, that everything had to be done within the framework of the law and the Constitution. And therefore, the question of amending the prosecution policy was seen as a mechanism to be able to allow the process to go forward.
Thank you.
Clearly, the intention could never have been to take away the discretion of the National Director.
Not to do a rerun.
Well, slightly, in the sense that there were outstanding matters that the TRC was dealing with, which were not driven to their logical conclusion. Therefore, post-TRC, a legal mechanism had to be found that would be able to give expression to what was desired by the President, as expressed in his statement.
Thank you. If you can now then turn to the DG's forum, I'm going to ask you to look at the transcript of the 12th of March. At page 38.
In which bangle?
She's coming.
You better have a chair yet.
In fact, I don't believe you need to go there, because you've just said that that was the intention of looking at a policy revision, and that the DG's forum was really looking at that to give effect to the President's speech. That is correct.
That is correct, Commissioner.
And really your evidence on that day was saying that.
That is correct, Commissioners.
So if you keep to that transcript of the 12th of March, and I ask you to go to page 40,
I'm there.
you at line 4, page 40 and 42 at line 3. You say that the task team is to consider and report on the following. You then go through what it is to report on: the criteria, the formulation of the guidelines, whether any of the two bills have already been formulated, can proceed with, bearing in mind the views of the intelligence services. And then at page 40, at line 4 to page 42, line 3, Mr. Vani asks you, thank you. Now, just from these terms of reference, do you accept that what was being proposed for this group to do was to effectively carve out a special regime for the handling of the TRC cases? And then you say, yes, I would agree, and I do agree. And further on in your answer, you then say, but of course, that is why, for instance, when we set up these committees, they, even consulted with the state law advisors to make sure that everything will be done in accordance with the law.
Yeah.
I saw somewhere in the document, in the bundle, there is a reference to an opinion received from the state law advisors, in particular Advocate Brewer, who was guiding the process. The state law advisors exist to make sure that before any bill is introduced into Parliament, it must be consistent with the Constitution. They certify bills before they get introduced to Parliament. And my question then, in response to your answer, Mr. Piccoli, is that it was put to you that this was effectively a carve-out for a special regime, and you agreed to that.
Well, that's correct. Because a mechanism had to be found outside of the TRC. Therefore, a special regime had to be put in place to be able to accommodate those outstanding matters. That's correct.
But the question that was asked of you was about the draft questions for the task team. It was not that the task team already had the draft policy. It was the questions, it was the engagements that were continuing with the task team. Because if you go back, it was
Let's look at the
question-
task. Let's look at the task of the task team and why it was called the task team. It's a task team for purposes of ensuring that we are able to take forward the outstanding matters of the TRC. And amongst those, there was a consideration on having to amend the prosecution policy so as to be able to accommodate those outstanding matters.
And amongst that would be a discussion, for instance, as to whether the legislation is appropriate, the law as it stands is still appropriate, is still fit for purpose, and whether it should be amended or not. Those are the discussions that you would have had.
That is correct. That's why, for instance, the opinion of the state law advisor was sought so that he can be in a position to guide the process to make sure that we stay within the framework of the law and the Constitution.
And so then-
Hence, the referral of asking for an opinion from the state law advisors. And then in this case, it was Advocate Brevet.
And therefore, the bottom line would be that you were very clear that it must be within the confines and prescripts of the law.
We are correct.
You might discuss whatever it is that you would want to discuss, but at the end of the day, what must happen must be within the confines of the law and in terms of the law.
That is correct. It had to be within the confines of the law.
If we turn to the same transcript, you were asked a question by Commissioner Gabriel.
Which page?
It is page 42, line 8, and then line 24. And the question that is asked is, would you not perhaps be seen as vectoring the discretion of the NPA? And then your answer is, yes, with the benefit of hindsight, and somebody can argue with foresight, it will not need hindsight. But we're dealing with a novel situation here, and for me it was that everything had to be done within the framework of the law. But now, as things turn out, it is clear that, my colleagues and I were working with, did not share my own thinking that, the genuine effort that the country was trying to put in place, because even the question perhaps comes up later about the DG's forum, and then can I say, I don't have to read all of it. At the end you say, but even at that stage, the question of the DG's recommending to the NPA simply cannot be, because it would be fettering the discretion of the NDPP or the NDP on the NDPP. That's your answer to this. So during your evidence, the commissioner asked if your proposal was not vectoring the discretion, and then you say with hindsight. But then if you look at, just to be clear, you would say that any bill that we proposed, or the task team or the DG's forum proposed, that would be passed, would not have been seen to be vectored in the discretion of the NPA. There would be a test as against that. Would I be correct?
You see, what I said, and I'm still saying now, is that you can always have a discrepancy between what is on paper, at a level perhaps of a theory or a proposal for amendment, and what is actually done in practice. And I believe that my bona fides in participating genuinely in the process was mistaken for a weakness, thinking that I could be manipulated, which I refuse to do. Because in actual practice, despite the amendment to the policies, there was no cooperation, which would have been the first step. So that's why I say now, with the benefit of hindsight, clearly, there were people who were not aligned with my thinking, who thought that the process could be manipulated, particularly when it came to decision-making.
But Advocate Piccoli, what I'm trying to find out from you is that the policy itself, I think that is what the Commissioner was asking you, the policy itself, on paper, was not about vectoring your
It's
discretion.
actually a typo. It should be fettering.
I thought it was a new word.
I read it as a new word.
And I wasn't going to argue, Chair, with my learned commissioner. You know, some people
Yes.
know more English than others. I really thought it
Yes.
was vectoring.
They say English is a broad language.
Sometimes very ambiguous.
Which could even change what you're thinking and question.
Yes, so that is what I'm trying to get to, that the policy, the discussions from your perspective, the process and the outcome of that process did not, on paper, as the policy fact, I nearly said vectoring again. I must look for a better word for myself. It did not impede your discretion.
On paper, I didn't feel that it was being interfered with.
Thank you. Thank you. And in fact, any bills that were proposed would not have passed if they were impacting on the discretion, on that discretion.
Of course, that's a discretion which I guarded jealously.
And that is why, for instance, the indemnity bill, and you say that your response was that you have no recollection of this bill, but this bill was never passed.
Yeah, because I never saw it. And I found it strange because as the DG of Justice, no bills that are going to be administered by the department will go through without the DG of the department having seen and having discussed the issues.
And also that the DG's forum's proposal that they will make recommendations to you was also, at an earlier stage, rejected.
Much earlier.
And this is part of the checks and balances that would have been in place to make sure that there is no, I like the word, vectoring of your discretion. Is that correct, Mr. Piccoli?
What's the question? Sorry.
That these checks and balances that the policy would have paid attention to would have made sure that there would be those checks and balances so that your discretion is not
Fettered.
vectored,
Fettered.
fettered,
There's fettering and factoring
and vectoring.
and vectoring.
So it will not be factor.
Yeah,
yes.
I'm sorry, Commissioners, I'm not clear on the question of the checks and balances that Council is referring to.
I'm saying, Mr. Piccoli, there would have been, from your perspective, advice from your law advisors. There would be your knowledge of the law. And in fact, all these, the points that I've read to you, that the indemnity bill was not approved, that the two-step process was not approved. All of those talk to the fact that there was no
No
fettering
fettering
of
of
your
the discretion of the NTPP.
Would I be correct in saying that?
That's why, for instance, even in my evidence in chief, I said that I personally, I didn't have problems with the amendments to the prosecution policy, though it was later invalidated by the courts of law, because I had that, discretion, which I felt that it can never be taken away.
Thank you. And then if we go to the transcript again, same date, we're at page 70. And you asked questions by Mr. Vani about the fact that it is a little puzzling that the task team seems to devote quite a time to addressing the question. And in fact, they reach a view that they say, should government, however, decide on a further amnesty process, legislation will be required since the mechanism and procedures of the TRC have run their course and can no longer be applied. If it is decided to follow the latter rule, an amendment of the Constitution is also proposed in order to enable such legislation. So the task team is saying, well, if government wants to go down this road, you will need an amendment. And your answer, right at the end of that answer, you say, you must still act within the constitutional framework and the legal framework. Therefore, if giving effect to what the president wanted would have led to a need to amend the Constitution, then it would be wise to say this cannot be achieved without introducing new legislation. This cannot be achieved without amending the Constitution, then leave the process open to those who make the law. And you stand by that evidence?
Yes, I do.
Now, what clearly comes out of this evidence, Mr. Pikoli, is that the task team makes proposals on the functions of the task team, but it doesn't translate into decisions.
You see, I think that's where the judges of the cluster had it wrong, because if we were to go back to the statement by the president, it was a question of the NPA being assisted by intelligence services and any other. Of course, intelligence services would have included civilian intelligence and crime intelligence, hence the involvement of SABC as well. So their task was to place information before the NPA for purposes of taking a decision.
And according to you, the policy gave content and substance to your understanding of how it should happen?
Well, the amended policy, as it stood then until it was struck off, I keep on saying this, that I didn't have a problem with that, because I didn't feel that it took away the discretion.
Okay. So if you can again go to page 75 of the same transcript. This is quite a long one that I want to read out to you. But maybe if I don't really need to. The Commissioner Gabriel asks you about the fact that we come through the TRC Act and the Azapo judgment, where the view is now to send back to this task team to say some of us are worried if we do not go ahead with the plans. And then you say that she would be right in her assessment. And then Mr. Vani says to you, Mr. Pikoli, on that point, and since it is your evidence that there was a division, you talk about the fact that not all of the task team members or the DGs agreed with your interpretation and your outlook. There was a division.
Yes.
That's the evidence.
I had my own interpretation and they had theirs.
Yes. And then you are asked a question. Since it is your evidence that there was a division, could you tell us who on that committee was in favor of eliminating private prosecutions and civil litigation? And then you answer, the members of that committee, they have already been referred to. And then you mention the members of the committee. You say it was SABC, it was DOJ, who were proven to be an obstacle, even at the time when the DSO or the PCLU required investigators to assist in the matter. The question that I have, Mr. Piccoli, is that now this discussion happens in 2004 about private prosecutions and the like in the task team.
It was carried over.
But surely it was not, it would not be correct to say that the Justice Department was also involved in this division on the wrong side, as it were, because you were there and you were in that department.
Yes.
So I'm saying, unless you're conflating the times, this discussion occurs whilst you are in the DOJ. So it could not have been the DOJ that was having these problems.
No, sorry. Thanks, Commissioner. My apologies. The issue is that even in 2004, when I was a DG of Justice, we had discussions about the possibilities of private prosecutions and possibilities of civil liabilities and all that. These were discussions. So, of course, there, my job was to also put out all possibilities on the table. And some of my colleagues who were DGs at the time didn't agree with me.
The point that I'm trying to...
But then, of course,
understand-
when I say then DOJ, it would be a situation when I were in 2005, when I'm now the NTPP. So my reference then to DOJ would have been when I was the NTPP.
It would not be in this period that you're talking about.
No, it would be because I was the DG of Justice in
Okay.
2004.
Thank you. If you can bear with me, I'm trying to find my place here. If we go to, if I may go back to Mr. Ackerman's affidavit. And it will be at page 229 of his affidavit. And in paragraph 25,
Yes, I've got it. Thanks.
oh, you've got it.
Yeah.
You're getting the hang of it, Mr. Piccoli. He says, once the guidelines were issued in December 2005, I wanted to proceed with the 5 cases I identified with good prosecution prospects and the 11 cases which required further investigation. And I won't read everything, right at the end of that paragraph he says, these included a lack of investigative capacity as well as difficulties encountered in convening the multi-departmental committee that was meant to advise the PCLU on what cases to pursue. So Mr. Ackerman in the affidavit says there was a problem because there was investigative capacity that was constrained or lacking.
Yes, except for one case, which was ready.
Yes, but the department doesn't work on just one case. The general difficulty was lack of investigative capacity. That's what he told this commission.
No, I'm sure he didn't mean to say that the PCLU had to have investigative capacity for all TRC cases. Those cases that were ripe for trial, there was nothing that stopped the NPA from proceeding with those matters while still trying to get more investigative capacity.
We would agree with you on that point.
Thank you.
But he says that the multi-departmental committee that was meant to advise on what cases to pursue, in that affidavit, he doesn't talk to political interference. He talks about the challenges and the difficulties that they had.
You see, I wish we could go back to also my affidavit at the Ginoa Commission, because that's the genesis. And you recall you were part of that Ginoa Inquiry. What I said then is what I'm saying now, and that is what is in my supporting affidavits for the Simbilane matter, as well as any other matter where I was requested to be of assistance. That is my position on this matter.
Well, I was asking you about his position, not your position.
No, I'm talking about in 2008, 2009, when I was at the Ginoa Commission, Anton Ackerman had not deposed to any affidavit. I'm talking about when I make reference to political interference, I'm talking about my own personal and practical experience that I went through.
But
I'm
sometimes,
not going to talk about what he says and what he believed in. I'm going to talk about my position, how I felt, how I interpreted the situation, and what my position was at the time.
we did, in fact, Chair, with Advocate Pikoli, promise each other we will not do the rerun of the Ginoa Commission.
Unfortunately, it will be unavoidable.
Well, you said, if I may, that this is not a rerun of the Ginoa Commission, and I said, no, it is not. Can I then take you to the supporting affidavit, and I accept that you ought to be giving evidence or helping the commission about things that you understand happened, the interactions between yourself and other parties, the minister, the department, and the DGs, even though occasionally you do refer to some other players and conversations that they had and the reports that you received.
That is correct.
Trying to shorten this. And if we can then go to the Ginoa Inquiry.
Pardon?
We're going to the Ginoa Inquiry, unfortunately, for me and you. It is in bundle 2, pages 135, para 260.
Apologies.
Page 135. In that paragraph, para 260, I think it is.
Pardon?
Para 260.
Yes, I'm there, the commissioners.
It says, I have not considered there to be an area of difference between the minister and me in regard to the handling of what is referred to as a post-TRC litigation. As it will appear from what is stated below, the minister was kept informed of relevant developments in regard to the process as it evolved, and she provided the support as required from time to time. The only request for guidance not responded to was flowing from the dispute relating to the implementation of the prosecution policy, which arose between me and Mr. Selebi. And that request for guidance remains unanswered. You are stating, really, the question is, you're stating that there was a material misunderstanding regarding the task team. You've given evidence on that.
Yes.
Oh, sorry, you are still
No, no, no,
following
I was just following as we are reading.
Oh,
was
it's
following
because
you.
I'm trying to be as short as possible.
Okay.
Yeah, sorry about that. So the question is that you stated that there was you state here and you've been stating in your evidence that there was a material misunderstanding regarding the task team about the understanding of its work and how it's supposed to work.
Yes, that is correct, Commissioner.
And your evidence here, as set out in this affidavit, is that the minister was not involved in that, in these differences.
Well, up to a certain level.
Well, there's no evidence here that she was
No,
involved.
no. I still have it in the affidavits where I point out the position that was taken by the Minister of Justice at the time. But here,
Here,
yeah, no, it's fine.
there's nothing like that.
No, I
And
just
in
want to
fact,
make
you
sure that
say
on
she
record-
supported you.
I just wanted to make sure that the record will reflect that at some point I had differences with the Minister of Justice.
We will get there, Mr.
Okay.
Pikul. And then can I take you to the affidavits that you have been deposing to throughout since Nkadimeng and the other cases? There are two affidavits that you filed that refer to the TRC cases. The one is the affidavit you filed around May 2008. That's the Ginoa Commission. And then the other one is at Bundle 2, that's the one we've just been through. And the other one is a supporting affidavit that you filed, and you've also made reference to it, the Nkadimeng case. And that is found in Bundle 2 from pages 1 to 47. And you refer to the extras from Ginoa in your supporting affidavit in Nkadimeng.
Yes.
Now, what is interesting is that in the two affidavits, the 2008 one and the 2015 one, you describe how you were handling the post-TRC cases, particularly the Chikani case. In that, in your 2008 affidavit, you speak of normal legal processes. You say, at paragraph 264, the foundation for the development
264.
of the 2008 affidavit,
Yes.
page 138.
138, yes, I'm there.
The foundation for the development of the prosecution policy is the statement of Mr. Mbeki. This is canvassed at para 3 of the TRC 1. And I'm not going to read the whole entire paragraph. And then if you look at the statement that you make, the affidavit you make in 2015, you say you have added some words there, and you say what followed was anything but the normal legal process. And in that you talk about the Mbeki speech, and then right at the bottom you say, former President Mbeki. Do you see where I am?
No.
I'm sorry. You see,
Which?
it says in April 2003, President Mbeki received
I
the
was still
final.
on 138. Have you moved from 138?
Oh no, I had moved. I'm sorry.
Where are you?
And in fact, I said to you, let's compare the two affidavits. So I didn't finish reading the entire affidavit, the entire 2008 affidavit. I'm now at the 2015 affidavit. Have you got it?
No.
Have I confused you?
On which page?
I'm sorry, I must have confused you. This is the 2015 affidavit would be bundle 2 from page 1 to 47.
1 to 47.
Yes,
Bundle?
2. That's the 2015 affidavit.
Yes,
You've got it.
I've got that bundle.
And then you've got the 2008 affidavit.
The Ginoa one.
Yeah. You were looking at it now, we've just
Yeah.
read it.
I think
That one is in
Yes.
page
Which page?
264. 264, page
264.
138.
Page 264.
Yes, at para 264, page 138. I suppose you can put a finger on the one and open the other.
Yeah, I'm on 2138A.
I beg your pardon?
So-
Am I confusing you?
These are 138.
Please, the thing must come towards you.
Yes.
The first one that I read was the para 264,
Yes.
page.
This is in this bundle.
And the other one is at page 7, I'm told.
Page 7.
Yes, the 2015 affidavit. And we're looking, I said it was from pages 1 to 47, but we're looking at page 7.
You are not telling me. I'm not at the same page.
Okay, okay. Sorry about that. You're looking at bundle 2, page 135.
It's the same bundle. Yeah, page 7. Yes.
Is that not his?
Yes, Councillor, I was on the same. You
I'm
moved
sorry,
me
I
from-
really am
From the right
sorry.
one to the wrong one.
I know, I'm really sorry.
Thank you, Commissioners.
So, shall we go to the 2008 one? And that one is in bundle 2, page 135. It's the same bundle, so you go with
135.
135.
Yes,
Put a finger
Yeah.
on the other one so that when you go to that one, you can get to it.
that's okay.
And my question was that in the 2008 affidavit, you say that the foundation for the development of the prosecution policy is a statement by Mr. Mbeki. Do you see that?
Yes, sir.
And then I say to you, go to your 2015 affidavit,
Which is?
which is at page 7. I had said it is from pages 1 to 47, but I'm referring you to page 7.
Yeah,
You've got
on
it.
page 7 now.
Yeah. And then it is para 18,
Yes.
and it starts in April 2003, President Mbeki received the final report.
Yes.
And I'm saying there's an addition there where you say at the bottom, regrettably, what was to follow in relation to the TRC cases was anything but the normal legal processes.
Yes, that is correct.
And then in the 2008 affidavit, at page 2, at para 287,
Paragraph 287.
87, you say the decision to prosecute those
Just
involved.
hold on, just hold on.
Sorry,
Paragraph 287.
87, yeah.
Which is on page 149.
149.
Yes.
You say the decision to prosecute those involved in the poisoning of Chikani became the central issue around which the dispute in regard to the functioning of the task team revolved.
Yes.
And then at 2015, you say, saw the unraveling of the attempts. So my question really is, having looked at the two affidavits, is that in 2008, when you testified before Ginoa, your affidavit did not contain any references to interference with your prosecutorial decisions in regard to Chikane.
No.
Yeah, that it was only in 2015 that you talk about political constraints.
No. I think if you read them together, in 2008, I say what I say, which is captured in my affidavit. In 2015, I deposed to a supporting affidavit confirming what I deposed to in 2008.
That's what I'm saying too.
Yes.
But I'm saying.
So I want to know where the contradiction is.
It's not a contradiction. I'm saying to you, in 2008, you mentioned nothing about what you mentioned in 2015. About
What is it that I didn't
political
mention?
constraints.
No.
I'm just pointing
no,
out
no,
that's what
no,
you
no,
did.
no. Throughout my testimony in the Ginoa Commission, which was based on my affidavit, I've always referred to the question of the problems that I experienced when we wanted, remember, the decision to prosecute in the Chikane matter was taken way back in 2004
Yes.
at the time of Minister Mabandla, who then gave an instruction to the acting National Director of Public Prosecutions, Dr. Ramayite.
So you are told.
No.
That's what you say.
Can
In
I-
your evidence.
Yes, because I was not at the NPA in 2004. Following the testimony of Dr. Ramayite, that he received a call to not to go ahead with that prosecution, which was decided on in 2004, that to hold back pending the finalization of the prosecution policy that was to be amended. 2005 was the year when this was being amended. Following the adoption of the amended policy, in 2006, we took a decision to go ahead with the prosecution. That's where there were these obstacles. And I say this amply in all my affidavits. If they are read together, there's nothing that says that if you omitted this and you didn't say that, but if you read them all together, they are consistent in terms of the obstruction that was placed in front of the NPA.
The point that I'm making, simply making, is that the 2008 affidavit did not contain any reference to the Chikane matter and the PCLU encountering political interference. That's the point I'm making.
No. If you recall, one of the charges that I faced at the Ginoa Commission was my insistence, sorry, Commissioners, it was my insistence on going ahead with the post-TRC prosecutions. The charter was brought by government, which was prepared by the cluster, led by Advocate Simelane, who was the DG of Justice at the time. They are the ones who were tasked with preparation of the charge sheet that I faced at the Ginoa Commission. It was precisely on this issue, and that's why I even said at the Ginoa Commission, when I was going further, it might not have been here, but at the Ginoa Commission, that's what I said, that there was political interference. Because the minister herself, she cannot deny it. Because the letters that she wrote to me, which are part of all these bundles, starting from the Ginoa Commission, where she said to me that her understanding was that we are not going ahead with these matters And my response to the minister was that I don't know how she might have, gotten that impression.
On that impression, Chair, it's gone past 10 o'clock, I'm told.
Yes, I think this would be an appropriate time to adjourn for tea, Ms. Moroka. I am informed that we have a technical fault with regard to our air conditioner, and that the technicians might require 10 minutes of our tea adjournment to attend to the fault. So we'll therefore reconvene at 11:30.
Can I find out if the fault is to make it warmer, not colder?
It's to make it warmer.
Thank you. You talk about it in paragraphs 32 and 33, bundle 2, the affidavit by Nkadimeng, in the Nkadimeng matter dated the 6th of May 2015, the affidavit we've been talking to.
Are you pointing me to the transcript or the affidavit?
To the affidavit.
Which one?
Take us along, Ms. Moroka.
It's bundle 2,
Page,
page 10, paragraph 27. So it's paragraph 32 and 33, have you got it?
No,
Have you-
I'm not there.
You're not there yet?
No.
Okay, let me
it's
try.
page 12, not page 10.
I'm indebted to the chair. It is page 10, para 27.
Yes, sir.
You're there.
Para 27 starts when the prosecution policy.
Yeah, but we're talking about the meeting with the ministers at Mr. Skweyiya's house.
No, then it's not.
That is on page 12, Ms. Moroka. That's on page 12, paragraph 32.
That's correct.
Yes, 32 and 33.
Yeah.
So it's page 12, not page 10.
Yes.
My apologies. And in that affidavit, you talked to that you were with the acting Minister of Justice, Mr. Jafta, Mr. Skweyiya, and I think Mr. Ngakula, if I'm not mistaken.
Yes.
And in that discussion, there was a concern about the impact of the decision to prosecute, and there was a concern that, according to your evidence in the affidavit, there was a concern that the ministers were worried about the 37, the reinstitution of the prosecution against the 37.
Yes, that's correct.
And in your evidence, you then say you then explained that your predecessor had already taken a decision somewhere in 2003 about there being no evidence sufficient to prosecute the 37.
I'm not so sure of the year, but it was during the era of, Mr. Yuka.
Yes. So you were explaining that to them.
Yes.
And then you say in your evidence that they seemed to be satisfied with your explanation.
They seemed to be satisfied.
And the Minister of Safety and Security appeared to continue to be worried about the involvement of Mr. Ackerman.
That is correct.
And part of it was in relation to who makes the final decision, whether it was yourself or Mr. Ackerman.
That is correct.
And then you
Commissioner.
explained that it's actually you who has the final say in terms of the law.
Yes, in terms of the special dispensation that was introduced by the prosecution policy.
But even the law gives you
Yeah,
the ultimate. Thank you.
I'm just adding.
Oh, thank you. So they were concerned, but in that meeting, nobody said you're to stop prosecutions.
In that meeting, nobody said so.
You say you do not recall what acting Minister Didiza's view was.
Yes, she was more passive in listening because she was the acting Minister of Justice. Therefore, she was not really familiar with the issues.
But those who were familiar with the issues never said stop.
They never said, stop.
They keep voicing their concerns, but they never say stop.
They were clearly voicing their concerns that if we go ahead with the prosecutions of the apartheid generals and other officers, then it would lead to pressure growing for ANC to be prosecuted, ANC members, particularly those who were denied amnesty.
Now, Mr. Piccoli, in the telephone call that Minister Didiza put through to Minister Mabandla, what was the feedback? What did Ms. Mabandla say about that? Because at 32, this is what was said. It seems that her view was asked for.
No, Commissioner, I'm not with you. Can I hear you
If I
again?
may, Chair, I'm also lost.
Let's see. The meeting was called by acting. I seem to have seen something. Okay, carry on. I'll just find it.
Yes, you may proceed, Ms. Moroka.
Thank you, Chair. I think, Commissioner Homo, it says called and not telephone called.
Okay, carry on.
Thank you. If I might then move to your interactions with the Minister of Justice, as she then was, May Bridget Mabandla. You refer to this interaction in bundle 2, page 18, para 47.
Page 18. Paragraph?
47.
Yes.
You talk about the fact that you are at a loss why she would be surprised about the fact that the prosecutions are still going ahead.
Yes,
And then
that's-
she says in that meeting, as you have undertaken to advise me in writing, I will appreciate if you could advise me urgently on the matter so that there can be certainty.
yes, that is correct, Commissioner.
In that meeting, you are rightly surprised according to you, but in that meeting there's no mention of the fact that the prosecutions mustn't go ahead. She says, just write me a letter so that there's certainty.
Yes, that's what she said at the time, that she was surprised.
Yeah.
Of course, taking the context, it's clear that she thought that prosecutions will not go ahead. That's why I was surprised that such an impression could have arisen.
But then she doesn't say to you, you have to stop it. She says, let's have certainty, write to me and tell me.
Yes.
And then you say later on that at paragraph 50, it is most likely that I've clarified my position with the minister either through a meeting or a telephone discussion. I would have confirmed with the minister that is not my intention to drop the TRC cases. You say you would have clarified the position with her.
Yes, in which case I also wrote to her quite an extensive response on the matter, and she never responded.
Let's look at that response. We're not going, because it was quite a lengthy response, there's evidence before the commission about that response.
Yes.
In that response, there is nothing that talks to what she had asked you to do. Tell me where we are with the TRC discussions.
Can you go to that? If you can point me. Because it does outline everything that had been happening until that point.
It does do that, but what it doesn't do is to say, Ms. Minister, apropos what you have asked me to tell you about the prosecutions, this is what is happening. That outline doesn't do that.
No, there's a chronology.
Can we then go to the
Sorry.
It is at page, your response is at, sorry about that page. It starts at 349 of bundle 1.
Switch on the second
Bundle
microphone.
1.
Bundle 1, 349. Have you got it?
On page
349. Starts at 349.
349.
Bundle 1.
I'm there,
You
Commissioner.
are there.
Yes.
We're not going to read through it, but shall we look at the pages? At 350, you talk about background information, and it's essentially about the Director General's Forum. In page 251, para 2.2, background relating to the amended prosecution policy.
Yes,
Paragraph 3, important features of the amended prosecution policy.
yes.
354, problems relating to the implementation of the amended prosecution policy. And then conclusion and way forward.
Yes.
She had asked about what we are prosecuting, because she was of the view no prosecution is happening.
No. No, we can go back to the letter that she wrote to me, because I would not have responded in a manner that would not have satisfied her request.
I beg your pardon?
I'm saying I would not have responded in a manner that would not have satisfied her request. So, when, as I said earlier on, there's a chronology of how things evolved from the time there was sort of a hold put on prosecutions commissioners. So I outlined everything, including the problems that we were experiencing as the NPA, insofar as SABS and even the DSO availing investigators. But on this particular matter, it did not require investigators, because it was a clear-cut matter. Even in terms of the amended prosecution policy, there was nothing that stopped the NPA from going ahead with the prosecutions.
But what I'm saying, what I'm confirming with you is that this letter doesn't talk to what she had asked you to do. She says here that if you could advise me urgently on the matter so that there can be certainty about going ahead with prosecutions. And then there's nothing wrong with the letter, but the letter goes to talk about your difficulties with the police or interactions in the task team, but doesn't talk to going ahead with prosecutions and how that is unfolding.
Can I just, out of desperation and frustration,
Not today, then.
then, which seems to be continuing to this day, which is on 5.4.
What is
Based on the,
continuing today?
again, pardon?
What is continuing today?
My frustration If I were to refer the commissioners to the last paragraph of my letter sent to Minister Mabandla, I say, based on the above, I cannot proceed further with these TRC matters in accordance with the normal legal processes and prosecuting mandate of the NPA as originally envisaged by government. Therefore, and in view of the fact that the NPA prosecutes on behalf of the state, I'm awaiting government's direction on this matter. This decision, firstly, as I alluded earlier, it was taken in 2004, and then the amended policy was in place. As the NPA, we took the same decision in January 2006 to go ahead with the Chikane matter. And again, in January 2007, we took the very same decision that was earlier taken, except that now they were joined by the former Minister of Police, Adrian Flock, and by the National Commissioner of Police at the time, Bona Merwe. That's why, for instance, I keep on alluding to the fact that this Chikane prosecution was going to be a test case on the question of prosecuting former apartheid generals. She never responded to this.
You do know about the meeting, you were not there, the meeting that she held with Ramaite and Ackerman, subsequent to this correspondence amongst yourselves?
Yes, I was not there because at the time I had to go for the funeral of my mother. And therefore, in my absence, they had to go and again brief her on the Chikane prosecution.
And Mr. Ackerman was asked a question on the occasion of being cross-examined, whether the minister had said stop the prosecutions, and he again said no, there was no instruction to stop prosecutions. Oh, sorry.
You know, I always talk about context being king, so that we are able to have the same understanding and interpretation of facts going beyond the piecemeal questioning, for instance, because this is going to miss a critical issue which forms part of my testimony. And this goes back to another meeting which I was faced with in Cape Town, the meeting of the 23rd of August, 2007, following the very same decision to go ahead with the prosecution of Bona Merwe and Flock and the others. Because immediately that matter went to court, which was on the 17th of August, 2007, there was this BLT article which sort of was saying, here we told you, that the NPA is pretending as if it's serious about prosecuting the former apartheid generals, but the motive is to actually prosecute the then President Mbeki and others, those who were denied amnesty. And this scarecrow has been there from the time the late National Commissioner of Police, Jackie Silibe, he kept on bringing this issue about the motive of the NPA. Clearly, the move was that we should not prosecute on these matters. Hence, I even faced charges for that matter at the Ginoa Commission. So if the government had no intention of stopping the prosecutions, then why did they have to have that as one of the charges that I faced at the Ginoa Commission? And of course, the record speaks for itself, how the matter was handled. Because at the Ginoa Commission, the government withdrew that particular charge because it would have caused an embarrassment.
I ask the question again, Mr. Piccoli. The minister at your meeting the minister at the meeting with Mr. Ackerman and Mr. Ramaite did not say, stop any prosecution.
Thanks for reminding me, Council. Commissioners, I was on the point of saying you must take these things in context. Because I was talking about that BLT article which appeared, which was forgery. Because BLT and whoever else was involved used a letter which was written by Ackerman about 4 years ago when he was doing a scan of the cases. And it was forged. What I did as part of the whole process, not piecemeal process, let's look at the integrity of the process, the wholeness of the process. Because once we realized that it was a forged letter that appeared in BLT, I gave instructions that this must be investigated. And Minister Mabanda said I must stop that investigation. And I refused, because it was still linked to the process of the post-TRC prosecutions. It should not be taken separately from the entire context.
So your answer to the question is we must take it contextually. My question is, from the documents that are before this commission, there is no order, directive, instruction from Ms. Mabandla to stop prosecutions. That's all the question that I'm asking.
No. We are right, Council. She didn't say so in so many words.
I think those are my questions.
You can derive intention from the context without it having been so blatantly put forward.
Thank you, Ms. Moroka. Ms. Ranto?
Chairperson, before we commence, can I just check if we can do re-examination?
Yes. I think it's time for you to re-examine.
Thanks, Chairperson.
Thank you, Mr. Vani.
As the Chairperson pleases, just a few follow-up questions. Advocate Bakuli, if we can just go back to questions that were put to you in relation to the constitutionality of the amended prosecution policy. As I understand your evidence, at the time it was discussed and devised, you were of the view that it was constitutional. But with the benefit now of hindsight and in the light of the judgment of Judge Lachodi, you accept that, in fact, it was unconstitutional?
I respect the judgment.
And then various passages from the judgment were put to you. And if we can go to the page of that judgment, I believe it's at page 40 of the cross-examination bundle. My team will just tell me which bundle it was. So it's the cross-examination bundle of the Ministry of Justice. So you were referred to paragraph 15.5 of that judgment in relation to the question.
15.5.
It's page 40, sorry. It's paginated page 40, and
Yes.
it's actually page 27 of the actual judgment.
Yes, I'm there.
Yes, so my learned friend for the minister pointed you to 15.5, where Judge Lahori said that the applicants have heard that it is not their case that the amendments expressly allow for an amnesty. But what you were not referred to is the last line of that paragraph, that this submission should be seen in the light of paragraph C2 read with C3 of the policy amendments. And then if we drop to the bottom paragraph, 15.5.2, when he refers to the Part C criteria for it, where prosecutors could decide not to prosecute on the basis of those criteria, Judge Lahori says at the second line, however, many of these criteria, in my view, are not relevant in deciding whether or not to prosecute. And actually that is a refrain that goes through that particular judgment. And then if we look at just a handful of the Part C criteria, I'm not going to take you through to the actual document just to save time, but examples of Part 3 criteria, Part C 3 sub C and D and E. The criteria included humanitarian considerations, the offender's sensitivity to the need for restitution, the degree of indoctrination to which the alleged offender was subjected, whether the prosecutor would facilitate or undermine the national project of nation building. So it's really on that basis that Judge Lahori ultimately came to the view that the amended prosecution policy was unconstitutional. So looking back, do you understand how the judge reached his conclusions?
Do I?
Do you understand how the judge reached his conclusions in respect of the constitutionality of the amended policy? Essentially, he was saying that the Part C criteria were not valid criteria for purposes of making a prosecutorial decision.
Yeah. I'm having a blank moment.
Okay, we can move on because that's just a legal question that I thought I would raise with you since those passages had been put to you under cross-examination. Let's turn to a question that my learned friend put to you in relation to the discussion of developing a new amnesty law or indemnity law. And this was when the Amnesty Task Team was busy working on what proposals to make. And you mentioned in your evidence, I think both in chief and under cross-examination, that this was done behind your back. And that's mentioned in the transcript at page 374 at line 10. Now we don't have to go there, but in bundle 1 at page 515, where the Amnesty Task Team report is included, there it's confirmed that the Amnesty Task Team in fact did develop a new indemnity law, which they said they would leave it in the hands of the DGs and those above the DGs to make a decision. So, can you comment on the fact that this law was developed behind your back and was never brought to your attention?
Thank you. Thank you, Commissioners. One, as the DG of Justice, if it happened during my tenure, which was up to January 2005, as the DG, I was not aware of that, neither did I have sight of such a bill. And if it happened around the time I was the National Director of Public Prosecutions, I also did not have sight of that bill.
Yes, I suppose the simple point that there were certain things that appear to be going on behind your back. But let's turn to the question put to you in relation to your supporting affidavit, where you confirmed your, this is the 2015 supporting affidavit, where you confirmed your affidavit before the Ginoa Commission back in 2008. And the suggestion was put to you by my learned friend that you did not raise any concerns in the 2008 affidavit, but only in the 2015 affidavit. And you pointed out that, that these paragraphs should not be read in isolation. I want to refer you to bundle 2 at page 144, paragraph 277, where you in fact did raise a concern.
So,
So that's B2, page 144, para 277.
yes, I'm there, Commissioners.
So there you state from the second line, had there been any suggestion that the task team members would report back to the DGs, who in turn make a recommendation to me in regard to the question of whether to prosecute or not, I would have objected to this, as it would have amounted to falling back to the position originally suggested before the guidelines. I understand that that was the two-stage process you were vehemently opposed to, which were established and which had been rejected by all parties as unconstitutional. And then if we can also turn to page 147, para 284, which is at the bottom of that page and goes on to page 148. And I'm not going to put the whole paragraph to because it deals with the same issue. You state in essence the proposal made by Mr. Selebi and subsequently supported by the DGs of Justice and NEA amounted to a revision to a two-stage process in which my decision on any prosecution would be dependent on a prior recommendation by an intervening committee of DGs, which would be subject to the same constitutional challenge as had led to the rejection of this proposal in 2004. So in fact, in your 2008 memo, would I be correct in saying that you were raising concerns about unconstitutionality?
That is correct, Commissioner.
And this was in relation to the workings of that task team and in the process of the role that they wish to play in your decision-making process. Is that correct?
Yes, that's correct, Commissioner.
And then lastly, let's turn to the exchange you had with my learned friend in relation to the passage in the letter that the Minister, then Minister of Justice, had written to you, in which she indicated that she was surprised that these prosecutions were going ahead because she thought you had indicated that they would not go ahead. And then a debate arose as to whether you had raised this concern in your subsequent memorandum to the Minister dated 15th of February 2007. That's in B2 at page 359. And if we can go to, actually it seems as if that memo is in separate places. It's also in B2 at page 56. Maybe that's an easier one to find.
I've got it.
Have you got it?
Thanks, Commissioners. Yes.
And then if you can go to your last page, that's on paginated page 66. And if I can refer you to paragraph 5.3, it would appear that there's a general expectation on the part of the DOJ, SABC, that there will be no prosecutions and that I must play along. My conscience and oath of office that I took does not allow that. So you pointed out firmly and unambiguously that there was an expectation on your part that there wouldn't be prosecutions in these cases. Is that correct?
That is correct, Commissioners.
No further questions, Chairperson.
Thank you, Mr. Vani. Ms. Ranto?
Good afternoon, Commissioners. Commissioners, may I propose that we take early adjournment for lunch to avoid interruption? I see the time is now 12:30, and perhaps we go and then return at 1:30 so that we can go on without any interruption.
No, I think we'll proceed and we'll take an adjournment at 1:10.
Thank you, Commissioners. Not a problem. Commissioners, before I start, just housekeeping rules. I have been advised by the Secretariat that the transcripts that the Commissioners will be working on, the ones that we referenced or that are indicated in our index. Maybe firstly, item number 5, the bundle of statement of General Jacobs is found in bundle 14. That would be statement 14 to 17th of April, Commissioners. And then for the purpose of transcripts, the ones dated 4th March 2026, 5 March 2026, 12th March, 13th March, and those are found in file 1.
In file 1.
File 1, Commissioner. Thank you. Thanks. And then lastly, Commissioners, the transcripts dated 23rd February 2026, 6th March 2026, 7th April 2026, 14th April 2026, 22nd April are found in file 2, Commissioners.
Yes, I suppose what you will do is, otherwise our desks are going to be cluttered. So you may have to refer each time to the file so that you can find it. Thank you very much.
We'll certainly do so, Commissioner. I must indicate that we will sparingly refer to transcripts unless it's necessary, because most of the issues that we deal with are of common cause.
Thank you.
Thank you, Commissioners. If I may start, good afternoon, Advocate Picoli.
Good afternoon, Council.
My first question relates to the period of political interference or alleged political interference by the police. From your point of view, when did the police start engaging in the alleged political interference?
Can you point me to a document where I said there was political interference? from the
Perhaps
police?
if I may assist and refer you to paragraph 41 of your, the affidavit that was filed in the Ngadimen matter. That would be paragraph 41, a page on.
Okay.
The Piccoli bundle, my apologies, commissioners, it's in the Piccoli bundle, page 16.
Yes, I'm the commissioner.
Perhaps if I may just point you to paragraph 41 where you indicate that early in December 2006, Dr. Ramaide
Yes.
informed you, yes. And then you would see that you carry on in paragraph 43 where you indicate that towards the end of 2006, it became clear to me that powerful elements within government structures were determined to impose their will on my prosecutorial decisions. You see that, Mr. Piccoli?
Yes, I see that.
Yes. The reason why I want to establish from you as to the political constraints, because you actually coined it political constraints in your affidavit. And I wanted to understand, when did the police in particular start interfering with your powers, prosecutorial powers from where you are sitting?
Well, thank you, commissioners. It was throughout the process where I was facing, or we were facing obstacles from time to time, from the time of talking about investigators being availed, which was something that I should not even have asked for, because that's part of their constitutional and statutory mandate to conduct investigations. To the time when National Commissioner Silibe would be talking about the NPA intending to prosecute the ANC members who were denied amnesty, to the time when I wanted to conduct an investigation on the forged letter, to the time when National Commissioner Silebe would be talking about Reverend Chikane not being consulted, and yet there was ample evidence that showed that Reverend Chikane was. So all these were obstructions. And this also then included, that would have been perhaps at the level of the bureaucracy, but then also in the meeting with ministers, again, the Minister of Safety and Security at the time, Mr. Charles Makula, is the one who kept on making reference to Ackerman and us prosecuting. So you could see a dialectical connection between what was happening at the level of bureaucrats and also this being aligned with the political thinking. And this taken together, these were proving to be obstacles in front of the NPA.
Okay. We'll come to details in relation to specific incidents. And the reason why it becomes important is because the terms of reference of the Commission do refer to some time frames. And in particular, the Galata affidavit, which is supported by yourselves and Advocate Ackerman. I mean, your confirmatory affidavits are used in the Galata group's founding affidavit. There are incidents of what Mr. Ackerman actually referred to as acts of political interference, and they have dates set down, I mean, or set out. in the affidavit. And that's the reason why I wanted to know exactly from where you are sitting, if you can give approximate period to say specifically this period. And I referred you to the period that you mentioned in terms of early 2006. I'm sorry, you said early December 2006. You remember that, Ms. Pikoli? In the paragraph 41 that I referred you to,
Yeah.
of your affidavit.
Saying what about 2006?
Okay. Your paragraph 41
Yes.
of the affidavit speaks of early December 2006.
Yes, I see that, Commissioner.
Perhaps if I have to make myself maybe clear as to why such an interest in that early December, and hence my question as to when. Evidence was led by Advocate Ackerman to the effect that on the 6th of December 2006, there was a letter of General Jacobs conveying the message by the late Commissioner Slebi about the issue of the involvement of the DG's forum and. You remember that?
Actually, the letter was signed off by the National Commissioner himself,
The letter of the
the late National Commissioner. That letter of the 6th.
6th of December 2006. I hope you're not confusing it with the one of the 6th of February 2007. We'll come to that one. You may be confusing it, if I
Okay.
may assist, yes.
And
Okay.
then you will point me in the right direction.
Perhaps if I may assist. Advocate Ackerman, in his affidavit, and so is Galata in his founding, relies on some letter of the 6th of December 2006 addressed to, on Ackerman's version, initially with the first affidavit, he said it was addressed to PCLU. And later, in his latest affidavit of October 2025, he said that letter was addressed to, he said probably he wasn't sure, it was addressed to the NPA. And then when he came here, and then I questioned him about the existence of that letter of the 6th of December 2006. He then said, in fact, he considered that it doesn't, he did not have a sight of it, and it may well be that it doesn't exist because he relied on the papers that were drafted by his counsel. That was Advocate Ackerman. And now, I'm giving you this background because I'm trying to point you to why the December 2006 becomes so significant in terms of understanding what informed your paragraph 41. In terms of early December, what incident was that of early December?
Yeah, thank you, Commissioners. I mean, the proper reading of this paragraph makes no reference to Advocate Ackerman. It says in early December 2006, I was informed by Dr. Ramaite of the renewed contention by Mr. Silibe that Reverend Chikane had not been consulted.
Dr. Ramaite, when he was here, he confirmed that he conveyed that on the basis of what General Jacobs had conveyed, according to what Ackerman said. That's what Dr. Ramaite said.
Well, I suppose they'll be able then to give a proper answer when they are cross-examined again.
So I can accept that the early December report by Ramaite may well be informed by that which he relied on in terms of Advocate Ackerman's affidavit.
Well, on the question of the letter, I don't know, but on the facts of Dr. Ramaite informing me, this was not anything new about the position which had always been taken by the National Commission, the then National Commissioner, the late Jackie Silibe, about this issue of Reverend Chikane not being consulted. So on the facts, I have no problems with the facts. As to how they were derived, then I'm not in a position to say anything on that. But on the facts, because I had personal knowledge of this.
but you can accept that you relied on what Dr. Ramaite told you that it was conveyed to him. You did not see any letter whatsoever.
Dr.
talking to
Ramayete didn't, sorry, Commissioner. Dr. Ramayete didn't raise anything new to me when he conveyed what he conveyed in December.
Perhaps
It was not anything new. As to how then he based himself, then I suppose then he'd be able to explain that. But the facts is what I know.
we will come to the facts, Mr. Piccoli. When you were informed about the renewed contention of Mr. Silebi that Reverend Chikane had not been consulted, that is what you
Yeah.
stated in your affidavit.
Yes.
Renewed contention, I suppose.
Yes, because it was not coming for the first time. That's why it's a renewed contention. It's not anything new.
Okay, we'll come and we'll come back to the Chikane matter. But you cannot give, you cannot say for sure as to exactly when you can attach a specific incident or time period to the police interfering. So you cannot. You are not able to give a period.
I've never referred to police interference. I've been talking about obstructions,
Even so, yes, obstruction. Let's say obstruction for that matter.
which might not be the same as interference.
Perhaps if I may.
Though there could be a coincidence in terms of the ultimate result.
Perhaps what I need to point out is that the commission was established to investigate as to whether there was interference, and it is labeled as political interference by the Galatas.
And,
And they do rely on your affidavit as part of demonstrating that there was political interference. So if I make use of the word interference, it's in the context of what is alleged by the Galata group supported by your affidavit.
Thank you, Commissioners. Yes, I'm the one basically who introduced the whole question of political interference in prosecutorial decisions. And I've provided ample evidence which led me to state what I'm stating now, that there was indeed political interference. Obviously, then the Kalata group relied on my affidavits, both in the Ginoa Commission and then also my confirmatory affidavit saying I'm confirming what I said at the Ginoa Commission in support of their application. That is correct.
Let's deal with your interaction with the late Commissioner Silebi, because it ties up with what you said earlier. And perhaps the letter of the 6th of February 2007, remember that letter of the late Commissioner Silebi? It was addressed to the late DG, Mr. Manzini, another one to Mr. Simelani, and then there was one addressed to you, but all framed same way, dated 6 February 2007. Remember those letters?
Yeah, I do. And my response.
Yes. Do you remember what your response was to Mr. Silebi's request that you should engage in terms of that which happened to be a misunderstanding?
No. Can you go back to that letter and so that we will read it? It was not a request to engage with me. It was a question of the DGs being given an opportunity to make their proposals or recommendations, and this is what I refused. Because I said then we are not on the same wavelength.
Okay, perhaps if I may refer you to specific letters to make it easy for all
Yes,
of us.
that would help.
The letter of Commissioner Silebi, it's titled, it's addressed to you, it speaks of outstanding TRC cases. And then this is how it reads. I have been briefed. It appears, sorry, Mr. Piccoli, is page 59 of Jacob's bundle, PCJ 13, PCJ 13.
Commissioners, perhaps you can read it out.
Okay.
What's the, with your permission, Commissioners.
It says, first paragraph, I have been briefed on the last meeting of the task team set up in terms of the cabinet guidelines on outstanding truth and reconciliation.
Can you raise your voice, please?
It starts off, I have been briefed on the last meeting of the task team set up in terms of the cabinet guidelines on outstanding truth and reconciliation commission, TRC matters. It was brought to my attention that in State versus Otto, and then in bracket, complainant Reverend F. Chigani, a decision on prosecution was taken without consultation with the respective departments. This is now the late Commissioner Levy's letter. The next paragraph, I have insisted that the complainant be consulted in terms of the guidelines on the basis that the Director General will have an opportunity to provide input before a decision on prosecution is taken. I am also under the impression that there is no common understanding on the process to be followed. In the last paragraph, my understanding was that the officials designated on the task team by the Director General will provide recommendations to the Director General, who will, as a collective, advise the National Prosecuting Authority as the decision maker on prosecutions. And then it carries on. But then what becomes interesting is your response to that letter. So you remember that letter?
Quite well, and it's a shocker.
No.
No.
Your
Can
sorry,
I,
Mr.
may I,
Pikoli.
may I just put my point across, because you were asking me about that letter.
Yes,
And I said the letter is not asking to engage the National Director of Public Prosecutions.
I accept that.
You accept that?
I accept it. It may not be.
No.
It's fine, even if it's not. That's not the question. I think I'm the one that is seeking to advance some question or canvass some question with you, Mr. Pikoli. So I simply wanted to remind you, I may have misquoted the contents, but I wanted you to just to remember the contents. Now, what is interesting is your response, and that appears on page 65 of the same bundle. Page 65, PCJ 16, Commissioners.
60.
No, it will be PCJ 1616, and the page number in the Jacobs bundle is 65, Commissioner.
1765.
Oh, no, it's bundled. Oh, we're using, sorry, Commissioners, we are using statements. We advise that Jacobs bundle appears in statements 14th to 17th of April. It would appear as though the Commissioners are using the pagination, the
Yes.
joint. But the annexure is PCJ 16, Commissioners.
16.
16, Commissioners. That is the response of Advocate Pikoli to
Yes.
the Sileni letter is.
We are on the same page with you.
Thank you, Commissioners. Are you with us,
You can go
Mr.
ahead.
Pikoli?
Oh.
Thank you. Now, your response to Mr. Pikoli's letter is that you refer to that letter of 6 February 2007, and then you carry on. I advise that it is clear that our understanding of the mandate of the task team, as well as the guidelines that Cabinet approved, are not the same. So, are not the same,
Yes, that's correct.
which means you agree with the late Commissioner Levy that there was misunderstanding in the role that had to be played by the task team.
Yes, he had one understanding, which was supported by the other DGs, and I had my own understanding, and
Yes,
I deferred
yes,
to them.
yes,
That's
yes.
correct, Commissioners.
In the circumstances, now the letter continues. In the circumstances, this matter, as well as other issues that have emerged in the course of the NPA dealing with the TRC cases, are currently being taken up with the Minister of Justice and Constitutional Development. So you indicate that you agree that you are not on the same page with him and the other DGs, as you said?
That is correct.
So there was misunderstanding. Now, what I'm interested in is, subsequent to that, you undertook to engage the minister regarding those issues.
Yes,
And this was also dealt with in that secret memorandum. that you addressed to Minister Mabanda?
Yes, perhaps calling it a secret memorandum. Let's say classified document.
Yes,
Yes.
classified. just to
Classified
make-
secret. That's correct.
Classified
Yeah.
secret, yes.
It's not a secret document, as if it was drafted in certain dark corners.
I'm trying to make just easy for us to understand the memorandum
Okay.
that we're referring to. Thanks for that, Mr.
Okay.
Pikoli. Yes, and in that memorandum, you do say that there is, in fact, you refer to what you coined as a deadlock between the NPA, the NIA, SABS, and that's how it is in that memorandum, unless you want me to take you to that memorandum, perhaps.
No,
to be specific.
I recall it,
You recall,
though I
yes.
might not have used the word deadlock.
I can point you to that one.
Okay, that's
It is said, but it's some impasse.
Yeah.
I think we can accept
Okay.
that there was, in fact, in your paragraph, in your affidavit, you refer to it as material misunderstanding.
I accept that.
You do not
Yes.
deny that, yes. Now, having noted or accepted that there was misunderstanding, what I'm interested to understand is what kind of guidance were you seeking from the minister in that regard?
You know, perhaps, I mean, even having referred to it as a misunderstanding might have been diplomatic language. Because it was more than a misunderstanding. It was deliberate obstruction, camouflaging as if it's a misunderstanding in the reading or interpretation of the guidelines, when the guidelines were quite clear. So that misunderstanding is a perfect, it's a convenient word to use, because it was a clear obstruction.
But in your affidavit, you're not talking to obstruction in that context. You said there was misunderstanding. I think we can accept, as I said, that in the memo you said it was a deadlock.
Yes, because I was using language which is more cooperative.
Yes, but we
Yes.
can accept you didn't see things the same. But then the question that I was interested, and I mean your response, from your response, what I was trying to establish was the kind of guidance that you sought from minister
Yeah.
in that regard. What kind of guidance were you seeking in that regard?
You see, one, Section 179(6) or so of the Constitution, when it talks about the minister's final responsibility over the NPA, and this is further expanded in Section 33, I think, of the Act itself. It talks about a close working relationship on issues relating to the NPA. So it was in that context, so that I'm able to get her own position on this matter, so that I'll be able then to act understanding where she's coming from, which unfortunately never came. It does not mean that I would have accepted whatever position that she was going to advise me on, particularly if it had a bearing on a prosecutorial decision. Because even that section in the Constitution does not talk about the powers to interfere in prosecutorial decisions. It's by virtue of her being a political principal, so that she can be able to explain politically the work done by the NPA through the reports or information that should be requesting in terms of Section 33 of the NPA Act. So I wanted to know what her position is, not that if I found that her position to be, not consistent with the prosecutorial discretion of the NPA, I would have opposed it. But I wanted to be clear as to what her position is, given all that I had outlined in the letter.
And can you accept that you never communicated your displeasure towards that letter to Mr. Silebi? You never responded to his letter to express your reservations in the context that now you are putting it.
Which letter did I not, sorry, Commissioner.
Okay.
I just want to be clear as to which letter
Okay,
that I did not respond to.
yeah.
Because I responded,
letter-
I
your-
responded to the National Commissioner Silebe, I responded to the Minister. Which letter?
Your letter to, or in response to Commissioner Silebe, gave an impression that you would be engaging the minister, and that's what you did not deny, that you were going to engage the minister, isn't it?
Can you look at the chronology as well? The letter to the Minister is post the letter that Commissioner Silebe wrote to me.
I beg your pardon?
I'm saying the letter that I wrote to the Minister comes after the letter written by the late Commissioner Silebe and my response to him.
Yes, I'm fine with
And
that.
then we had then this discussion, which was subsequently reduced to writing in the form of the letter of the 17th of February 2007. The chronology tells you, or should be able to.
Yes, but
Yeah.
what I'm saying, Mr. Piccoli, is that your response to Mr. Silebe was that you were engaging the minister on these issues, isn't it?
That I was going to engage the Minister.
Yes, you're
Yes.
going to engage the minister, yes.
Yes.
And what I asked earlier was whether you ever responded after this letter that you wrote to Mr. Silebe. I'm sorry, the 6th of, the same day. Remember, you responded on the same day to say that you were going to engage with the minister
Yeah.
on the same day of the 6th of February.
And I never, sorry, Commissioners.
Yes, yes. Yeah, you responded on the 6th, and after that, you never responded to Mr. Silebe again after engagement with the minister, did you?
I never made any undertaking that I'll get back to him. I said I will engage the Minister.
You would engage the minister. Oh, now, what was Mr. Silebe expected to do whilst you engaging the minister?
I responded to him to say that I don't agree with what he was saying. And then I indicated that I'm going to engage the Minister, which I did. And I didn't make any undertaking that following my engagement with the Minister, I was going to go back to him. Because his position was quite clear, and my position was quite clear. There would have been no reason why I needed to go back to him, because I had made my position clear to him as to what my response is to his letter. I was just informing him that I'm going to engage the Minister further on this matter, and we did engage with the Minister.
So we can accept that you left it on the note that you agree with him that there was misunderstanding between you and him.
Well, in the sense of agreeing to disagree, yes.
Okay. Also coupled with that, we can accept that you never told or you never said to Mr. Silebe that in terms of what his letter was saying to you, you deemed it to have been interference with your powers.
No, I didn't tell him that. He knew what he was doing.
And then we can proceed to deal with paragraph 29 of your affidavit. That's on, sorry, Commissioners, paragraph 29. That's on page 11 of the Piccoli bundle. My apologies, Commissioner. It's on page 11.
Which bundle?
The Piccoli bundle. So it's part of the Galata Group. It's Galata Group volume 2. It's bundle 2, actually. It says Galata Group volume is bundle 2. Musi Piccoli bundle.
And we are on page?
11 of that bundle, Commissioners. Specifically paragraph 29 of the affidavit of Advocate Piccoli. Have the commissioners found it?
Yes.
Oh, thank you, commissioners. My apologies. I thought you were still searching for it. You found it, Mr. Piccoli?
I've got it. Thanks, Council.
That paragraph starts off when you say, meanwhile, in early 2006, I had approached the then Commissioner of Police, the DG of Justice, and the heads of NIA and the DSO, also known as Scorpions, requesting them to nominate senior officials to assist the PCLU in accordance with the prosecution policy guidelines. Now, the latter part, unfortunately, the SAPS and the NIA never provided PCLU with the necessary support to conduct its investigation. Now, starting off with early 2006, when you engaged the DGs, when would that be? What kind of
Well-
engagement was that? How did you approach them?
I think it was, if I recall, it was through a letter that was sent to all the DGs, including the National Commissioner.
The one inviting them to nominate officials?
Yes.
And then, following that, your affidavit reads, unfortunately, SABC and NIA never provided PCLU with the necessary support to conduct this investigation adequately.
That is correct.
And then we go to paragraph 38 of your affidavit, that is...
Before you
on-
proceed, Council, may I, Commissioner, just so that we don't move away from this?
I'm going to ask you a question. I wanted to refer you to...
I thought you
that.
were moving away from this paragraph.
No.
Oh.
My questions, it sort of deals with both what is stated there and the paragraph 38. Now, in paragraph 38,
38.
yes, that will be on page 14 of your bundle. And then it is stated that the task team met for the first time on the 12th of October 2006. You see that?
Yes, I do.
And then you confirm that you attended the opening session.
That's correct.
And then the same paragraph on the next page, where it starts by, I received reports. You see there, I received reports from time to time on the activities.
Yes,
Yeah.
I do that.
And these reports, I suppose, I don't know what gave me or made me to believe, because there's some typo there, to believe that the committee was functioning in securing the requisite cooperation from other agencies which had previously been missing.
Yeah.
Yes.
Uh,
Now,
sorry.
yes,
That is correct, Commissioners?
Yes.
Because I was getting the impression that they're sorting things out.
yeah,
And it
that is
turned
why I'm
out
going
not
to
to
ask
be.
you a question. Yeah,
Yeah.
definitely. That's why I want to deal with failure to provide investigators. Or, I don't know where to point to, but there's something, somewhere in your affidavit where you say police resistance, something like that, or police not cooperating. But let's accept that there is an allegation that the police were not cooperating. Let's just operate from that lack of support from the police.
Yes, I agree.
Okay.
If we agree that what I'm saying is that the police didn't cooperate.
Yes.
That's correct.
That's fine,
Yeah.
yes. And then what I want to find out from you is whether the ITT minutes, ITT Interdepartmental Task Team, the ITT, the minutes of the
Yeah.
ITT
Yeah.
are reflective of progress that was being made, or the task team members agreeing that there was progress being made. And I can specifically refer you to the minutes of the 16th of November, 2006. And that is on PCJ 9, Commissioners. In the bundle of Jacobs, is page 54. Unfortunately, I'm not so sure, Commissioners, in terms of the reworked bundle. But it's PCJ 9. It's the ITT minutes of, it would be page 1751 of the Commissioners' bundles. 1751.
1750.
I think with the bundle that you have, it would be page, do you have Jacob's bundle there? You do have it in
Yes.
that file. Yeah, page 54. Sipo, can you assist?
I've got minutes of the meeting of the task team on TRC cases,
Yes.
16 November 2006. Are we on the same page?
Yes. In those meetings, the minutes, the second page, 54 of the same minutes, on the second page, the second paragraph from bottom, because the minutes are not numbered, unfortunately. You see where it is recorded that it was agreed that the task team has indeed made progress, as there were already cases identified for investigations and interim recommendations made on some cases. You see that?
Yes, I see that.
Was this brought to your attention?
Yes, because I've always been saying this, that there was a stage when it appeared that they were working well together in terms of the team doing what was expected of them, in terms of placing whatever information that was at their disposal. So things appeared to be working
So-
at that time.
Is it your evidence that things were not working?
You see, I don't know how I should put this thing now, because I've been saying more or less the same thing, commissioners, that we did have problems, but at some stage it appeared as if things were smooth. That's why, for instance, even on a simple matter, let alone the question of providing investigators, where it's stated here that certain cases were identified that required investigations and so forth and so forth. That's just preliminary work that was being identified, scanning the environment in terms of what was in front of the team. That's the simple work. But the real issue is, how does this have an impact insofar as carrying out what was expected of them? That's ultimately you measure the outcomes, not the output.
Do I understand your evidence to say that there was no work done?
I never said there was no work done, because I called them, they did come to the meeting, we did agree that they must be assisted, and things appeared to be going on.
When you say appear to be going on,
Yes, until such time, because, again, I'm sorry, commissioners, again, I'm going to repeat myself about...
maybe if you
About
allow
the
me to,
context.
sorry, Mr. Piccoli, if you can allow me to finish off what I was going to ask you.
I thought you had finished.
No, because I'm trying to pick on what you said, things appeared to be done.
That is correct, commissioners.
Okay.
Appeared to be done.
Meaning they weren't actually being done. Is that what you are saying?
Exactly what I'm saying is what I'm saying.
And you were the principal of the ITT, is that not so? Principal, you
Of-
were the principal of the ITT.
When?
The task team.
Not when I was NTPP. Not when I was NTPP.
Okay. Perhaps if I may refer you to the minutes of 12 October 2006.
Page.
PCJ 3, Commissioners, it's page 22 of Mr. Piccoli, or the bundle that is in front of Mr. Piccoli. PCJ 3, Commissioners.
3 or 4?
3. The TRC, it says minutes of TRC committee meeting 12 October 2006.
October.
Oh, you've got it.
So in our pagination and for the record, it's page 1719.
Page 171.
Yes.
We'll
I'm
rectify
there,
this,
Commissioners.
Commissioners. We will work on the pagination according to the consolidated one. We really apologize for that, for the inconvenience, Commissioners. Perhaps, Commissioners, before we even go to PCJ 3, we can go to PCJ 2, just before PCJ 1. PCJ 2, in the bundle that is in front of you, Mr. Pikoli, is on page 21. TRC committee members there. You see it there?
I'm there, yes.
Yes. What is indicated down there, it says principal or principals, I think in plural. Advocate Vusi Pikoli, and then it's got Kailami Pillay, NPA, and then it's got Loiso Jafta Presidency, MC Milani Justice, and then somebody from NIA. But these are recorded as principals. So you're one of the principals of that committee, is that not so?
Well, I'm sure it's one of the things that might have missed my attention as to what was meant by principal. But clearly, in terms of what the president had said, the NPA was going to be assisted by the intelligence community together with any other departments. So perhaps it might have been used in that context. Because I didn't have an engagement other than addressing the people then who were brought in by the various departments, outlining what was expected of them. Perhaps in that context, I'm not going to argue either way. I'll accept that. Yeah.
Yeah, you were the custodian of the process, of the task team. You were the custodian of the process.
Yes, because it was left to the NPA to deal with the matter within the normal legal framework. In that context, that is correct.
Yes. And now I'm going back to where it appeared that the work was being done, when in actual fact, on your version, the work wasn't being done.
Yes, because it ultimately led to that.
Now,
Though an appearance was given that since that meeting, because the first meeting they had was in October, to talk about how they're going to approach their work and what was required.
now my question.
So which meant that all the parties did come together to look at what was required to be done.
I can accept that, Mr. Pikoli. My question is now, as the custodian or the principal of this task team, what mechanisms did you have in place to make sure that you were not misled, that the work was being done when the work was not being done?
Well, I was relying on the reports that I was getting from Dr. Ramaite about what was happening.
Other than those reports, there was nothing whatsoever to measure
Other
whether
than-
there was performance.
Sorry.
Yeah, I wanted to understand. Other than that, there was no measurement tool or mechanisms in place to make sure that the work indeed was done.
Well, for as long as Dr. Ramaite, who the PCLU fell under his leadership. So he was there, he was chairing the meetings. Dr. Ackerman, Advocate Ackerman, fell below Ramaite. So for me, if they are not bringing up any issue, then I've got the right to think that things are going on until such time that they bring issues, like they did bring issues on the question of some of the obstacles.
So we can accept that what was reported to you by Dr. Ramaite and Advocate Ackerman and others who were coming from NPA may not be a true reflection of what happened from your version.
Well, if there's reason to believe that they might have misled me, then there's something which can be proven through them being tested in during their cross-examination.
How did you establish that the work was not being done?
Pardon?
How did you establish that that which appeared to have been done was not done? How did you establish that? How did you come to know?
What?
Remember?
No.
Yes.
You see, Advocate Ackerman kept on raising the question of not having investigators. And there was also this question of him being seen to be an obstacle, until such time that I said Dr. Ramayite should be the one who's chairing those meetings, so that they do not use Dr. Advocate Ackerman as an excuse for not doing the work.
So who was making excuse for not doing the work? Because of Ackerman?
No, the question of providing, because the issue was that for as long as Ackerman is the one who's involved in the work of the PCLU, we were not going to get investigators
That was coming from who, if I may ask, Mr. Piccoli?
because they were never provided, because of the insistence on removing Ackerman.
Who's they?
It reflected itself.
If I may
It
establish.
was coming from the National Commissioner, the late Jackie Silibe.
So when you say they, you're talking about the late Commissioner?
Well, of course, the National Commissioner of the Police, so I take it is the police. He represents the police. He's the National Commissioner of the Police.
And then other entities were cooperating?
I don't know how many times I must say this. I was saying the police were an obstruction. The DG NIA sided with the National Commissioner of Police. The Department of Justice agreed with the interpretation that was provided by Jackie Silibe in terms of what was needed to be done, which I differed with.
So when,
Those were proving to be obstacles.
when you say they, you talk of
Primarily,
SABS, Justice, NIA.
this charge was led by Jackie Silibe.
Ms. Ranto,
Commissioner.
I think we've long passed our lunch adjournment. I had indicated that we'll adjourn at 1:10. But just to know for housekeeping purposes, since we have quite a number of people to cross-examine Advocate Piccoli, how long do you think you will still require for your cross-examination?
Commissioners, if I have to be very honest, we still have quite a number of issues to converse with Mr. Piccoli. To say an hour, I don't think I'll be telling the truth. It will definitely be in excess of 1 hour, perhaps 2 hours.
2 hours?
2 hours at maximum, Commissioners.
In that case, we will adjourn for lunch and reconvene at 14 hours, 10 minutes.
Thank you, Commissioners. It's PCJ 9 on page 54 of your bundle. And then
The date of the
your page, 16 November,
16,
16, yes.
which would be, because I've got 6 November, which is PCJ 6.
Yes, PCJ 6, with the, it's page 1735 of the Commissioner's Bundle.
1735.
Yeah, 1735, yes.
Yes, I'm on that.
You recall when I was asking whether there were reports?
Oh, here,
given.
the handwritten one refers to 16 November, but the typewritten one refers to 6 November. Are we on the same page?
No, 16, not 6, 16. There were 2 meetings in November, the 6th and the 16th.
But you are at PCJ 6.
Or 6.
Is it PCJ 6?
Apologies, Commissioners, I wanted to say 9, my sincere apologies. PCJ 9, 9, yes, the minutes of the 9. So 9 would be
Page
1749 of the Commissioner's Bundle.
1749.
No, for yours, sorry, Mr. Piccoli, yours is page 54.
No, I think I'm using the same.
Oh, are you using the same of,
Yeah.
if it's the same bundle as the Commissioner's one, it would be PCJ 9 would be 1749.
1749. Which is PCJ 9.
Yes.
Thank you.
So the next page. Yeah,
Yes.
yeah. I simply wanted to take you, but just to remind you where we ended off, where I pointed to the fact that it was reported that there was progress made, but of course you made your point to say that they made you to believe that there was progress when in actual fact there wasn't much being done by the task team. Remember that?
Yes, I remember that, Commissioner.
Okay. And then, again, if you look at the minutes of the ITT meeting for December 2006, that would be PCJ 10. PCJ 10 in the Commissioner's bundle would be 1752 Commissioners. You've got it?
Yes, I've got it.
Okay. If
This
you
is for December 2007.
Well, there's a 6 there to show that there was a typo. Can you see the handwritten 6?
Oh, so that's 2006.
Yeah. It has since been established that it was actually 2006, not 7. And perhaps if I may just take you to the next page of those minutes.
The next page, it's
Yes.
new minutes. After this one.
You've got it.
This page
Same
ends.
minutes,
This page
page-
ends on 4.7.
No, there's a page after that one. Oh, sorry, my sincere.
There is no page.
No, there
Ms.
is no
Ranto.
page. Commissioners, the mistake that I made, I thought it was same minutes. In actual fact, I wanted to refer to PCJ 11. I really do apologize, Commissioners, because it's one page only. PCJ 11, Commissioners, would be 1753.
Dated 29th January 2007.
Indeed, so yes. No. The one about the feedback. PCJ 10. Sorry, Commissioners, this is rather quite, yeah. PCJ 10, the intention of PCJ 10, my sincere apologies. I was deliberate in terms of dealing with PCJ 10. So I do apologize, Commissioners, if I take you back to PCJ 10. PCJ 10 does just before PCJ 11. So that would be the Commissioners'
1752.
1752, thanks, Commissioner. You've got it.
Yes, I'm on the page.
Still talking to the issue of no reporting or no progress being made.
No, it's the minutes that I have
Yes, what I wanted to find out from you is whether this issue that was raised here, or the issue that was recorded in the minutes, insofar as General Jacobs informing the meeting that there was a letter sent to the provinces calling upon provincial commissioners to provide investigators, whether that was brought to your attention that there was such a step taken by the police.
What's the question?
The question is whether the fact that the police had taken steps by way of writing to the provincial commissioners to provide a list of investigators, so whether that was brought to your attention by your representatives in the ITT meeting.
Yes, as I said, that there was an impression created that things were going on smoothly, commissioners. But also you see some of the minutes here where also there's reference to an objection by the NPA for the inclusion of the Bratz as one of the investigators, which again would be an indicator that things are not really as smooth as they are meant to be.
Sorry, Mr. Piccoli. The issue of Bratz was discussed earlier. That was during the auditing that happened. Remember, there was an audit by Office of Advocate Ackerman and the police.
Yes.
And the police one happened to have been aided by Senior Superintendent Bratz. That's where the issue came from. But here, we're not dealing with that issue.
Yes.
What I want to find out from you, in terms of the minutes of the 4th of December 2006, is whether the fact that the police had taken steps to write to the provincial commissioners to request list of investigators. And in fact, in the minutes, it is recorded that some had already provided a list of those investigators that would be assigned to carry out these functions. So my question is, was this brought to your attention?
Insofar as these minutes are concerned, I have no reason to dispute what is contained in the minutes.
So,
We should take care of the question that you're asking.
so we can accept that there were steps taken
Yes,
as far back as
as
before
indicated in the minutes.
December. Thank you for that. And that also spills over to the meetings of 29 January 2007. That's now the PCJ 11. That is, PCJ 11 is the page just after PCJ 10 commissioners, would be 1753. That's where General Jacobs indicated that the list had been provided and already some had been availed. So we can accept. I think I'm not going to take it beyond that. As you said, Mr. Piccoli, that you're not going to dispute that something was being done.
Yes, if you must read all the minutes, what the minutes say. Yes,
Okay, thank you.
that's fine.
Let's move on to the Chikane matter. In your evidence, and that comes from, or it stems from your affidavit, is that the first decision to prosecute in the Reverend Chikane matter
Yeah.
was taken by Dr. Ramaite in November 2004 already.
That is correct.
And that was before your appointment as the NDPP.
That is correct.
And then your affidavit then indicates that in February of 2006, you also took decision that there should be prosecution in the Reverend
I think
Chikane.
actually it was in January 2006
It is in
when-
February.
when the NPA took that decision. Anyway, either January or February, but early 2006.
Okay,
Yes.
but you did take decision early in 2006. Do you remember that?
Yes, that's correct.
Now, the commission has been informed that the issue of Reverend Chikane is one of those that culminated in political interference, if I may put it that way. That's not your version. I'm simply trying to tell you what has been said. And perhaps if I may say that Dr. Ramaite, in his words, during his testimony, said that the meeting of the 29th of January 2007, in fact, collapsed because of the Reverend Chikane matter.
And what is the question?
Yeah. So now, I simply wanted to give you that background. I'm coming to the question. In your affidavit, it is stated that on the 6th of November already, you had taken decision to prosecute the accused in the state versus auto matter, in the Chikane matter,
6 November, which year?
2006.
No.
Okay.
No, that's incorrect. I wish you could point
Let-
out where I say that. Where I say that.
Perhaps if I may assist you in
Yes.
paragraph, that's paragraph, this was 43. Let's see paragraph.
Paragraph 43 of.
Sorry, I'm looking at the decision. Commissioners, I'll refer you to the relevant paragraphs, but that's where the affidavit, it is stated by
If I may assist-
Advocate Piccoli
Okay.
that he took, no, what he said is that subsequent to Dr. Ramaite's decision to prosecute in November 2004,
Four.
which was pended because of the legal opinion that was to be obtained and the coming into operation of the public, the prosecution policy.
No, it was not on the basis of a legal opinion that was sought. Dr. Ramaite says that he was told by the minister to put the prosecution on hold pending the finalization of the prosecution policy. There's nothing about any legal opinion that was being sought, other than the finalization of the amendments to the prosecution policy.
Okay.
Yeah.
The issue of legal opinion came up in the evidence of Advocate Ackerman.
That was subsequent,
Okay.
when they were pleading that they were granted indemnity, and which thing was rejected. That's when we sought legal opinion.
But perhaps let's go to what transpired during the ITT meetings.
Can I just to be clear on the chronology, on the question of the prosecutions. The decision was taken in November 2004, that was stopped. It was the whole process of the amendments to the prosecution policy, 2005 until they were adopted. And then the NPA took a decision in early 2006 to proceed. Again, there was this up and down about Reverend Chikane agreeing or not agreeing, which of course we have put that to a dispute. And so that was the second time. The third time that the NPA took a decision to prosecute on the matter was again in January 2007. So the NPA had taken already 3 decisions to prosecute. And this finally happened on the 17th of August, 2017. Just on the chronology.
Do I understand you, Mr. Piccoli, to say the decision to prosecute in the Reverend Chikane matter was taken finally in January 2007?
No, I'm saying it was taken in 2004.
Yes.
That process was stopped, right, pending the finalization. And then with the guidelines in place, as of December 2005, again, a decision was taken early 2006 to proceed with the matter, which is also reflected in the minutes of the task teams that were meeting. So that was the second time in 2006. But again, there were delays because of all these obstacles that were placed on the path of the NPA, particularly by the late General Commissioner Silibi, referring to Reverend Chikane not agreeing with the prosecution, which was not true. That's the second time. Having gone through all that, in January 2007, again, we said we are proceeding with this matter.
Let's get the chronology right.
Yes.
From November 2004, when Dr. Ramaite took decision not to proceed with the prosecution, whether it is said by what the minister, I think Dr. Ramaite will come and explain that, but what we have now is that it's in your affidavit
It's
that
correct.
Dr. Ramaite
It-
did not proceed with the prosecution pending the amendment to the prosecution policy.
He was told not to proceed after the NPA had taken a decision, a prosecutorial decision. A member of the executive put a hold on the implementation of a prosecutorial decision pending the finalization.
Were you present during that
Doc-
meeting, Mr. Pikoli?
Well, this is not in dispute so far.
No.
If there's any evidence that will show that this is incorrect, then we'll have to listen to that.
No, but were you present in the meeting of minister or alleged meeting of Minister Mabanda
Reading
and Dr. Ramaite?
reading the affidavit of Dr. Ramaite and what I subsequently got to know in 2005 of the prosecution being placed on hold. Now, I was there in 2005, and there were no prosecutions because this was pending the finalization of the prosecution policy.
Yes, I think that one I don't have a difficulty with that, but I wanted to understand the decision in your affidavit. There is nowhere where you say the minister, that's in paragraph.
No, I didn't say that. You're right.
Paragraph 24 of your affidavit, that would be page 9 of the Pikoli bundle, Commissioners. Paragraph 24. This is the affidavit of Advocate Pikoli in support of the Nkarime matter, the 2015 affidavit. Page 572 of the consolidated bundle. It is stated that the initial decision to prosecute 3 security branch members, former Colonel Smith and former Captains Otto van Staden, was taken prior to my appointment as NDPP. This decision was taken in November 2004 by Dr. Silas Ramaite in his capacity as acting National Director of Public Prosecution. However, he instructed that this matter and all other TRC cases be held over all other TRC cases pending the development of the guidelines to deal with the TRC cases that were to be incorporated into the prosecution policy. So there is nowhere in your affidavit where you say the minister instructed Dr. Ramaite. Your affidavit tells the commission that Dr. Ramaite took decision not to pursue that state versus auto matter pending the prosecution policy. There is nowhere where it is stated in your affidavit that it was minister that instructed him to do so.
I could not have said that because it was never said to me. I can only to pose to things that I can be able to speak to.
Yes, but what I'm saying is that the version that you say Dr. Ramaite was instructed, it's not in your affidavit, Mr. Pikoli.
Are we not running a bit in circles?
I think perhaps it's I'm losing.
Right.
Well, Commissioner, I'm not so sure, but what I wanted to find out from the witness is pursuant to Ramaite's decision. There was, well, the decision to prosecute, or that was pending. There was nothing going on until he came into the picture. But I think then the dialogue ensued when the witness wanted to explain who took the decision, and perhaps we got sidetracked But fact of the matter is that I wanted to check with Mr. Piccoli that from what he has written in his affidavit, November 2004, up to your appointment, as you say, in 2006, the reason why there was no prosecution in the Reverend Chikane matter was because of the prosecution policy, not because the police refused to provide any sort of assistance.
And I never said that.
And then on your version, perhaps to assist, it's in paragraph 27 of your affidavit, page 573 of the Commissioner's bundle. Yours, I think, is page 10, where you indicate that I therefore gave the initial instruction to proceed with the prosecution in February 2006. So that's what I was looking for.
Commissioners, I could not have said that because the Chikane matter is one of those cases that were low-hanging fruit, because that matter didn't require any investigation, any further investigation at that stage. It's clear as all that.
Which means it was ready
So
for
I could
prosecution.
not have said that SABC then obstructed an investigation or didn't provide, because that matter didn't require investigations from SABC or investigators from SABC. It was a low-hanging fruit that you could make use of.
Then I might then take you to paragraph 60 of your affidavit, paragraph 60. 60. 60 commissioners would be page 586 of the commissioner's bundle. I think in the Piccoli bundle that you have is page 23. The paragraph 60, and that's your affidavit, Mr. Piccoli. It is stated that a full prosecution in the Chikane matter case, or in the Chikane case, would have produced greater truth and accountability. However, there was strong political resistance to this prosecution and the pursuit of the other political cases. It was further clear to me that the government, and in particular the then Minister of Justice, did not want the NPA to prosecute those implicated in the Chikane matter. This was due to their fear of opening the door to prosecutions of ANC members, including government officials. Now, your statement then continues to say, moreover, I could not rely on the police to investigate this case and the other political cases thoroughly.
Yeah.
Therefore, a plea and sentence bargain was, in my view, the most appropriate. That's when now you were justifying why that. But now my question would be, and you just said it, that the investigation had been completed by that time. Now, the question would be, why would you seek reliance on the police to investigate if the matter was ripe for hearing?
Thank you, Commissioners. Can you go back to this matter? In 2004, when the decision was taken, it did not involve Agran Flock and Van der Merwe. It was limited to the 3 police officers in 2004. And the NPA, in its assessment of the matter, felt that they could proceed with the matter without any further investigations, just to bring to court the 3 accused persons in the matter. That was in 2004. The art prosecution was stopped or put on hold by the minister, pending the finalization. 2006, we go through all these processes. In 2005, 2006, we take again the decision. I think it was when we took the 3rd decision on going ahead with the matter in 2007, when Van der Merwe and Flock came out of the wood to say they are the ones who gave instructions. Now, this changed the whole picture, because now we have got additional accused in the matter whose role was not very clear, and they were not forthcoming. They made presentations, though, that they should not be prosecuted. They made representations. we looked at those representations and rejected those representations. Already there was this, a reluctance because of Jackie Silibe keep on saying that Chikane does not want this prosecution. We had to have more consultations. I also had to have consultations with the Reverend Chikane on the matter, who said to me that insofar as he is concerned, at a personal level, he has forgiven those. But when it comes to the law, he leaves it at the hands of the NPA and would accept whatever decision. Now, the commissioners will also remember that I was put through a long and tortuous process having to explain why do we want to go ahead with this prosecution. Oh, clearly the hand of government was out already, that they don't want this prosecution to go ahead. Particularly now it involved a general. For the first time, a general was to be prosecuted. And for the first time, a former minister, apartheid minister of police, was to be prosecuted. So it upped the stakes in terms of trying to resist this. You will recall, commissioners, I don't have to remind you of this, we have gone through the documents, that the legal representative of the police, Jan Wagner, who at some stage was a state attorney when I was in justice, was the one who kept on telling Ackerman that there's a dossier that they have that has been compiled by the police, which would have implicated ANC members. So they were playing on this fear. That's why I'm saying then, having Van der Merwe and Flock joined, would have meant that more investigations would have been required so that their role becomes clear. And also the question of who else was in that hit list that they had compiled. And it would have needed investigators from SABC to assist the NPA to unravel all that was not, on the fore around the questions of proper investigations. That's why I was saying, for instance, for us as the NPA, it left us with no option but, to agree on the question of, in terms of Section 105, capital A, to enter into a plea and sentence agreement. Because I kept on saying it's on record that the NPA institutes criminal proceedings on behalf of the state. And we have got members of the executive, we have got bureaucrats, the police, who are supposed to be forefront in the investigations. They are proving to be an obstacle. That's why I was saying that had the matter gone full trial, we would be knowing more than we know today. Because by nature, Section 105A is not going to reveal everything. But that was the minimum we could achieve under the circumstances.
Okay.
And the circumstances spell out for themselves.
Mr. Piccoli, I will come to the reason given by Advocate Ackerman. In fact, the transcripts in terms of what led to the plea bargain and so on. We'll come to that one. But my question was, when were you, as the NDPP, ready to prosecute in the Reverend Chikane matter?
In 2006.
Yes. So you were ready as far back as 2006.
Yes.
And then the delay in prosecution, what was the delay?
The delay in prosecuting that matter was brought about by the late National Commissioner, Jackie Silibe.
We'll get to that.
Because he kept on, giving us all sorts of stories.
We'll get to the interaction. So we can accept that from 2004, it was Dr. Ramaite's decision, and then you came in 2006, and you insisted that there must be prosecution.
I came in 2005, and then in 2006,
You took
was taken.
decision. Okay,
Yes.
okay. Understood. And then the minutes of the ITT of the 6th of November 2006. That's PCJ 6 commissioners, that's page 1735 of the commissioners manual. What is reflected in that minutes is that the Reverend Chikan matter was discussed, but what came out of that meeting was that it had to be ascertained. His attitude had to be ascertained in terms of whether or not he wanted to prosecute. And that is what is recorded in the ITT meeting, that you were not present, or you did not attend.
Who?
You were not present.
I didn't attend all those
Yes,
meetings.
yes. So that is why I'm telling you about what is recorded in those.
In the minutes.
In the minutes, yes. What comes out in those minutes is that the committee or the task team resolved that Reverend Chikane had to be consulted to establish what his attitude was. It is in the minutes. You can't dispute it, that it was discussed.
No, let's read the minutes.
Subsequent to that,
No, I'm sorry, Commissioners. Can you go to the minutes?
yes,
That it was agreed by everybody in the meeting that
Go to
Reverend Chikane was going to be consulted again.
so, well, the minutes on page, the first page of the minutes, the last paragraph, okay? It is, however, worth mentioning that when Advocate Ackerman informed the meeting that a decision to prosecute has already been made by the NDPP on the Reverend Chikane case, Josias indicated that recommendations of the task team are necessary because the National Commissioner is of the view that Reverend Chikane is not interested, is of the view that Reverend Chikane is not interested in prosecution of the matter. Now, according to the minutes, this issue was raised by Josias, and we have been informed that it's Major General Josias Likalakala
Of subs.
of SABS, Crime Intelligence.
Of subs, yes.
He suggested that contact has to be made with Reverend Chikane to ascertain his attitude. And then there's a handwriting that I'm not so sure. Ackerman informed the meeting that NPA discussed the matter with Reverend Chikane. So Advocate Ackerman did say that it was discussed, yes. in
But
that
it was
meeting.
already discussed.
Yes.
Already discussed
But then
with
that-
Reverend Chikane.
Yes, he did, indeed. According to what is recorded here, Mr. Piccoli. But the next paragraph then says, according to Advocate Ackerman, the complainant, Reverend Chikane, indicated that he leaves the matter in the hands of the NPA. Then this is the important part coming to your question. It was then decided that the latter's attitude be ascertained, and the matter was therefore closed pending feedback on his attitude. That's what the ITT resolved on the 6th of November, that pending consultation with Reverend Chikane, the matter had to be regarded as closed pending feedback. So that's what they resolved, and you cannot dispute that.
You see,
Because
for
you are
the
not
umpteenth
present.
time, you see, these are the delays that
But can we accept that it is what is recorded, that the ITT resolved that it be pended?
no. It's going to be a to and fro.
No,
It's going to be a to and fro because in that very same meeting, Ackerman did indicate that Reverend Chikane was already consulted.
Mr.
What would have been,
I think Mr. Pico-
what purpose would it have served again to go back to Reverend Chikane?
Mr. Piccoli, for us
And-
to
and- and the
rationalize.
issue-
Sorry,
can I-
Mr.
can I-
Piccoli. Sorry, Mr. Piccoli. I don't think I asked you as to whether it was reasonable for them to do so. The question was, what is recorded there? You cannot dispute that it was the decision of the ITT that there should be consultation, right or wrong. They resolved that there should be consultation. Would you disagree with me?
They could have taken that decision, it's fine.
Yes. And then subsequent to
But
that.
I'm not so sure whether it was a unanimous decision because that thing arose as a result of what Leka said, saying that, again, the National Commissioner was saying that Reverend Chikane. So again, it will be same pattern, which indicates,
Well, we can accept how you interpreted that. It's something different, but what is recorded in the minutes, you cannot dispute because you are not there. that it has been agreed, or it was then agreed, because or decided.
Stands to reason that I can't dispute anything when I was not there.
And then 22nd of January, it's common cause, Advocate Mahaga confirmed, Advocate Ackerman confirmed, you also confirmed that there was a meeting held with Reverend Chikane by Advocate Ackerman and Advocate Mahaga, 22nd January 2007.
Yes?
It's in your affidavit. And then also you stated in your affidavit that following that meeting of the 22nd of January 2007 between Reverend Chikane with Advocate Ackerman and Advocate Mahaga, you then caused a letter to be sent to the attorneys of the accused in the Reverend Chikane matter.
Yes.
Yes. And it is also common cause that subsequent to that, on the 29th of January 2007, the ITT meeting set on that day. You were
Yes.
not there, but
Yes?
the record speaks for itself that that meeting took place. And then in that meeting, unless I don't want to waste the commissioner's time by going to the same minutes, because I think they've been referred to those minutes many times. But the very same minutes of the 29th of January, the Reverend Chikane matter then was again discussed.
Yes?
But this one is raised by the SABS, if I say South African Police Service, in terms of General Jacobs, that's PCJ 11. PCJ 11 Commissioners, is page 1753 of the Commissioners Manual. The third paragraph says, Advocate Ackerman SC requested members for their inputs with a view to finalize the draft report to be submitted to the National Director. Commissioner Jacobs indicated that he was made to understand that Reverend Chikane was not interested in the prosecution of the accused in his case. Therefore, he needs to be consulted and the matter needs to be discussed with their principals before making recommendations. So that was on the 29th of January. Now, what Dr. Ramaite testified on, insofar as this meeting is concerned, because for whatever reasons, apologies, he wasn't there, but Dr. Ramaite said that meeting actually is the one that brought an end to the life of the ITT, in a way, because he said it became chaotic because of the Reverend Chikane matter.
Yes?
You also can, yes. But what is interesting was that the meeting that was held with Reverend Chikane on the 22nd of January 2007 by advocates Ackerman and Mahaga was never disclosed in this meeting. Neither was your letter of the 25th of January that you sent to the accused in that matter of the Reverend Chikane matter. Was it also disclosed to the meeting that there was that kind of consultation? And I wanted to understand as to what would have been the reason, or what do you make of that? Your officials' failure to inform the meeting that such consultation had already taken place on the 22nd of January 2007.
Thanks, Commissioners. I'm not going to answer on behalf of my officials then.
Yeah, you don't have to. I wanted to understand what do you make of that, because even your letter was never disclosed.
You see, I think also they must have reached a stage where they kept on saying the same thing and but SABS would be saying another thing and to and fro. I don't know why.
Don't you think?
And it would not have made any difference in terms of the decisions that were already taken.
Well, it may well be so, but the chaos that
The chaos.
that meeting, chaos that took place in that meeting would have been prevented, isn't it?
Yeah, I don't know whether it had a bearing on a prosecutorial decision.
What I'm saying
The
is
chaos.
that the tension, whatever we call it, that occurred during that meeting would have been prevented if they had simply informed the meeting that there has been consultation, another one with Reverend Chikane, and therefore this matter can be regarded as finalized because it was still pending insofar as the ITT meeting was concerned.
In all meetings where there are differences of opinion, there will be tension. I don't know whether it would amount to chaos. Because that chaos clearly did not affect a prosecutorial decision.
I think here the issue was your officials that represented you during those meetings, who were aware that there was an issue
Ms.
that was...
Ranto, I don't want to interfere with your line of cross-examination, but there must be a purpose, unless you have a version that you will be tendering in this regard.
Perhaps is the one of, the question that I asked is what the witness is making of that, because
Yes.
Advocate Ackerman made it clear that they did not inform the meeting about their meeting with Reverend Chikane. And when he was being asked as to why they did not, he said he did not see a reason for that. And all I want to find out from you, what do you make of that?
I'm sure the record will show that in some of those meetings, Ackerman and Maga did talk about them having had a consultation with Reverend Chikane. These minutes, these PCG minutes, do indicate that the matter was raised by Ackerman and Maga, that Reverend Chikane was consulted. I don't know what that meant,
Advocate
them
Pikoli,
repeating the same thing
Perhaps,
over
no,
and over again.
no. What Advocate Ackerman said before this commission was that he did not disclose that he had met with Reverend Chikane prior or few days before the meeting set. Whilst he was well aware that that issue was outstanding, because if the minutes that I referred you to, the 6th of November, 2006, I pointed it out to you that in that meeting, it was said that this issue of consultation or ascertaining the attitude of Reverend Chikane would be regarded as closed until he was consulted. What then followed was a consultation in January 22, 2007, but that was never disclosed during the meeting of the 29th of January by
But
Advocate
Ms.
Ackerman.
Ranto, you're going back to what the chair has already ruled.
Okay. Chair, I will step off, commissioners. I'm not satisfied with what the witnesses, whether the
Yes, you may
witnesses
take
answered
that in argument, Ms. Ranto.
it. Thank you for that, Chairperson. The next issue is the investigation of the forged note.
Oh,
Forged note,
yes.
the one that you spoke about.
The one that appeared in the build.
Yes, about the prosecution of the ANC leaders. Yes, indeed. You have confirmed to the commission that that investigation that you said you commissioned never took off. It never took off because of the minister's instruction, right?
Yeah, but again, context.
Okay.
This article appeared in the build, I think, a few days after the appearance of Flock and Van der Merwe and others, which was on the 17th of August. And then there was this article in the build, and we issued a statement as the NPA disputing that. And then soon thereafter, there was this meeting on the 23rd of August, 2007, where I was called by the ministers to talk about this issue.
Yes.
And that's where I informed the ministers that I have asked for an investigation into this letter that appeared in the build, which Ackerman obviously disputed. So within a month, I got suspended. So I was never able to follow up as to what then happened. Because there's so many other issues between the 23rd of August to the 23rd of September,
Okay.
just prior to my.
All right.
So I won't know what then finally happened. Because as of the 23rd of September, I never went back to my office.
There's evidence that was presented before the commission by General Jacobs in terms of forensic investigation that was conducted into that document. And it's common cause that the outcome of the investigation said that there was no tampering or there was no forgery of that handwriting that was said to be the one of Advocate Ackerman. And you accept that we can't dispute that in the absence of any other expert
I do not know-
contradicting that.
I do not know anything about that.
You don't know
I do not know anything about that.
about that?
Yeah.
Okay. Well, you may not, as you say, that you were no longer there. But if I were to tell you that the forensic investigation says that there was no forgery, there was nothing other than that report that came out, you would accept that that's the only evidence that we have?
I don't know who carried out the forensic investigation. I do not know. I do not have the facts, so I don't want to say anything about it.
Okay, fine.
But at the time, the person who was said to have been the originator of that letter denied it, and this was Ackerman himself.
Yes.
So that is the issue perhaps between them, Ackerman and those who were involved.
Well, he did deny it, but maybe just to find out in Advocate Ackerman's denial, I'm not so sure whether you were still in the NDPP, but perhaps just to understand whether you are aware of what he said was later found. I'll just inform you, just to check whether you carry knowledge of that.
No, I don't know. And I
Okay.
suppose it's a matter that will be put to.
No. So, no, just allow me to ask the question. Maybe you yes or no, whether you know.
No, I've already answered the question, Council. I've said I can't say anything. I do not know the outcome of the investigation.
Okay. And the fact that the note was found in Advocate Ackerman's computer, the same note bearing same features?
That's for Ackerman.
Yes.
To
His
respond.
his evidence before the commission is that a note bearing similar features to the one that was subjected to forensic investigation was found in
The
his
witness
computer.
has no personal knowledge. Will his answer assist us in any way?
Maybe he was aware that it was reported to him, but if the commissioners think it's not
answer
taking
would
us
not
anywhere,
us-
I will proceed
That will sound
with the
like
next
a
question.
conjecture, a speculation from your side, Council.
No, it cannot
If
be
you say that
speculation.
perhaps I knew about it, I don't
Well,
know.
Ms.
how
Ranto,
you have reached that.
let's proceed.
Yeah.
We have time constraints.
Thank you, commissioners. The last thing that I want to engage with Mr. Piccoli on is the lack of cooperation. You remember you indicated even from the beginning that you never spoke of interference, but you spoke of people being obstructive, and there was also lack of cooperation from other stakeholders. You accept that, Mr. Piccoli?
Yes.
Yeah. In your evidence in chief, you took the commission through your responsibilities as the former Director General of Justice, coming to the NDPP, and also what stood out in terms of what you testified on was about Chapter 3 of the Constitution. I think more specifically it was Section 41, the one that speaks to cooperative governance. And that's when you explained the need to have that JCPS so that there has to be that cooperation. You remember that?
That's correct.
Yes. So now, with what has happened, going back to that misunderstanding that you had with the other DGs and the National Commissioner, my question is, now with the benefit of hindsight, if all parties, including yourself, had adhered to cooperative governance or principles of cooperative governance in dealing with the issues, would you agree that it would have assisted in dealing with that kind of lack of cooperation?
That's why it's in the Constitution that organs of state and various levels of government should work together
Yes.
in ensuring that the mandate of businesses, of government is carried out. It can only be through collaboration and cooperation, but of course it does not mean that at all times, because even that chapter does make provision that issues can even lead to court, but courts should be the last resort.
Indeed so. Meaning everyone, including yourself, were obligated to explore that collaboration in terms of what was required of each one of you. Yes.
That's correct.
And then Advocate Ledwaba, who used to be with the DSO, testified before the commission that when they were confronted with a similar situation regarding, I think he called it a turf of war between the SAPS and the DSO, they had to develop a service level agreement.
I'm sorry?
The police and the former Scorpions, let's say Scorpions. Yeah, what he said was that at some point when they experienced that, that's now NPA experiencing that because DSO resorted under NPA, right? The
Yes, that's
DSO.
correct.
Yes,
That's common
yes.
cause.
What I'm trying to just share with you was that in his evidence, he said this thing of the police and NPA not working together occurred during his period when he was with the DSO. But for them to deal with that, they had to come up with a service level agreement that was then demarcating in terms of what the police had to do and what the DSO had to do, given the fact that they had what almost looked like a dual mandate over investigation, even though we know that the Constitution obligated the police, but the DSO had investigation powers, isn't it?
That's common cause.
Yes, so what I wanted to say, with the benefit of hindsight, maybe the service level agreement between the NPA and these other role players would have perhaps assisted in dealing with this, which seemed to have been either misunderstanding or people saying it's not my responsibility, it's not your responsibility. Don't you think so?
More so that the NPA Act also had a provision for an interministerial committee of the relevant departments, which committee hardly met. And you can find this in the report of the first Judge Khampepe Commission, how and what led to this tension spilling over, because they were never properly managed, even at a political level, let alone at the level of operations.
Thank you for that. So the issue of SAPS, NPA, PCLU, they were just working in a manner that's not so organized. We can accept that.
Well, there were attempts to work together. I mean, also there are, limits to where, when you feel you are being undermined in terms of the mandate that you have. Cooperation does not mean succumbing to manipulation or being undermined in terms of your authority. It must be principled, working together.
I can accept that, but everybody had to adhere to that, isn't it?
Certainly.
Thank you. And then, as you said during your reign as the DG, remember, you informing the commission that you chaired the DG's forum.
Yes.
And you also informed the commission that the intentions were good at that time, isn't it?
Yes.
And you also informed the commission that you all endeavored to give effect to what the president required of you to do during his statement. It was April.
Yes.
Yes.
2003.
Yes. And then you also indicated that.
Which was not without precedent.
No, I
Because,
can accept that.
Yeah, I'm saying the type of the expectations that, from the DG's cluster once
Yes.
you have that
Yes.
policy pronouncement.
Yes.
Yes.
Yes. And yes, I'm just saying that you did inform the commission
Yes.
that the intentions were all good. And you were all determined to give effect to what the president wanted at the end of the day.
So I thought.
And you also.
So I thought.
I beg your pardon?
So I thought.
Yes. And also to say that it was uncharted water, so to speak. It was a new thing for everybody. This whole thing of the TRC.
Indeed.
Yes. Commissioners, may I just check with my colleagues?
Yes, Ms.
Just 2
Ranto.
seconds. Thank you. Oh, yeah. Yeah. Just one last thing. The issue, taking you a little bit back to what you testified on earlier about
Earlier
the
today
letter,
or
yeah, today,
evidence today.
yeah, the letter of the late Commissioner Sleby. Remember the 6 February letter, 2007, yes. 7, the one that you responded on the same day to say that you would engage the minister and you never went back. What you said, you did not see a need to respond beyond that letter.
No, don't put it as saying I had an obligation to go back, because I never made such an undertaking.
Yes, yeah.
I only informed him that I was going to engage. Yes.
Okay. The issue, I mean, your failure to engage Commissioner Sleby further on the issue. Remember, there were talks, even Dr. Ramaite said there was a meeting requested that you should engage and discuss the matter. And that was proposed by the late Commissioner Sleby. Remember that he wanted you to talk about it, to have a meeting around it.
No, this is the point. You are taking us back before lunch, where you were saying that letter written by National Commissioner Silebe was asking for an engagement, as if I was to agree to a meeting. That letter was not saying that. He was talking about what he was expecting, which did not happen.
Yes.
Yes.
No, I can accept that.
Yeah,
But
no,
my
I want us
question
to be
is,
clear.
okay, fine, Justin, let's agree, it's fine. But my question is, don't you think if you had engaged Commissioner Sleby, Mr.
Was there an obligation for him, because he wrote to the minister, was there an obligation on him to revert to Commissioner Sleby? Was there any obligation, or was there any undertaking by him to go back to Mr. Sleby?
Or is there a
Commissioner-
version that will be putting Ms. Ranto
Commissioner
in that
Woodil,
regard?
perhaps if I may answer it to Commissioner Hom. Dr. Ramaite will come back, but he did say that he said he would go back to the police, but we'll wait for Dr.
We're
Maite.
talking about
Yes.
the letter.
Yes, but
the
my
letter.
question, no, for insofar as Commissioner Khumu's question is concerned, we're talking about the accounting officers, the heads of the department that form part of the JCPS cluster that were required in terms of the Constitution to collaborate to promote cooperative governance. And that is why I'm asking whether there was an obligation in terms of what was written on the letters. That is not what I was interested in, Commissioner. Is that which he mentioned that there was a need for them to collaborate. And I'm simply asking whether he did not see
We
any
know what
need.
the Constitution says, I think in Section 195 or thereabouts, that organs of state must cooperate with
Yes.
each other and must, endeavor by all means not to take each other to court. We know about that. We know about that. But the witness has said, there comes a time where you agree to differ.
But Commissioner, what I'm trying to, unfortunately, I couldn't even get to where I wanted to get with the questioning of the witness, because whether he was obligated or
Whether-
not,
if-
Commissioner Khoma.
Listen, if the chair allows, go to that point there.
Chair, the issue wasn't whether he was obligated or not, but what was informed, or what was testified before the commission, Dr. Ramaite will come, is that because of that lack of engagement, the ITT collapsed. And perhaps if that's what I was trying to elicit from the witness, that perhaps if he had engaged his counterparts, there would not have been a collapse of ITT. Whether right or wrong, I simply wanted the witness to say what his thoughts are around that. That's all what I wanted to ask. But I suppose Mr. Piccoli is not going to answer because the commissioners have already, I think, taken an issue with that line of questioning, and I will leave it on that note.
No, may I respond, Commissioners? I'm sure, Council, you will not dispute the fact that I nearly broke my back trying to bend insofar as cooperation is concerned. There was a point beyond which I couldn't go without breaking my back. You can never accuse me of not having cooperated with the judges cluster or with the ministers. I explained myself where I'm coming from. That is on the record. It can't be that for there to be cooperation, one had to act outside of the limits of the law, which issue I was being forced to, and I refused.
Okay. Commissioners will end it on that note.
Thank you, Ms. Ranto. Mr. Vani?
Thank you, Commissioners. Just a few questions by way of re-examination. Advocate Pikuli, it was put to you by my learned friend for SAPS. There were various questions around the communication from Commissioner Salebi to yourself and the other principals, the other DGs. On the 6th of February 2007, that correspondence is in a few places, but the one I'm looking at is in Bundle 2, at page 172. That's Advocate Pikuli's letter to you, copied to the other DGs. I'll just wait for you to get a copy in front of you. I want to establish from you, Advocate Pikuli, what was the real nub of this letter, and I want to refer you to the third paragraph on page 172, as well as the second paragraph on 173. And you'll notice in both paragraphs, the essential complaint is that before you may make a prosecutorial decision, you have to wait to hear from the DGs who wish to make their inputs. So is the nub of the matter that you were effectively, from their perspective, not allowed to proceed until you had heard from the DGs, and that until then your hands were tied?
Thanks. Yes, Commissioners. I think that's the point I tried to make when I was responding to the letter, when I referred to it as a shocker. That's precisely that.
And then following up from that episode, and just to save time, we're not going to go through the correspondence because I think we're all familiar with it. You then approached, you wrote to Salebi indicating that there was this fundamental misunderstanding, as you said so in diplomatic terms, and that you would then be approaching the minister. My learned friend for the police made the suggestion that because you didn't come back to Commissioner Salebi, that you had left him in the dark, that he didn't know what was going on. And if I record your response correctly, you stated he knew what he was doing. So was there any need for you to come back, given that Salebi was completely alive to the issue since he had raised them in the first place?
That is correct, Commissioners.
And then there was an exchange between yourself and Ms. Ranto in relation to communications that had taken place from early December, I believe the 4th of December 2006. Although we weren't referred to those particular emails, so I won't go there. But then ultimately we get to the same communication, and in your response, you pointed out that, while there were times when you had an impression that things were smooth, you gave the example of the NPA, I believe through Ackerman, objecting to the proposal that a certain Superintendent Brits be involved in the investigations, and it was put to you that that was at a different time. But in fact, I can refer you to PCJ 6 at page 38. That's a task team minute from the 16th of November 2006. And SEPA will just assist you there.
Yeah.
But just to save time, I'm going to continue. So in the second paragraph of that meeting, that's 16 November 2006, Ackerman raises his objections to the proposed reappointment of Mr. Brits to assist SAPS in compiling their report. And we know from other evidence before this commission, through Ackerman himself, that his objection was because Brits had been a former security branch member. So in fact, the issue around Brits was brought up at the same time, was it not, and for legitimate reason?
Yes, Commissioners, thanks. This is the point that I was trying to make, that these minutes must be written, the minutes must be read as a continuous event, not just isolate and be selective. Because taken, in their context, it's clear as to what was happening in terms of reports being made, progress being made, apparent progress, lack of progress. So taken together, one can be able to know what was actually happening. Thank you, Commissioners.
And then if we can move to the exchange you had with Ms. Ranto in relation to acting NDPP's Dr. Salas Ramaita's exchange with then Minister Mabandla on the question of suspending work on the TRC cases. And let's first start with the transcript. That is the transcript of Dr. Ramaita's evidence. It's day 12, 23rd February 2026. And we'll take a look at pages 27 to 28. Okay, we don't seem to have the transcript before the witness. With the leave of the chairperson, I'm just going to read a small section into the record. So this is at line 12 on page 28. Mr. Ramaita, he's asked the nature of the concern he expressed. The nature of the concern was it cut through the prosecutorial independence of the prosecution. Advocate Sony. Okay, now what? He then said the minister insisted that the prosecution of all TRC cases must be put on hold until the development and adoption of guidelines. Ramaita, that is correct. Sony, is that what she told you? Ramaita, yes. Sony, so she starts off with the particular arrests that were going to be made, and now she then says, but it does not apply only to that case, but to all cases. Ramita, yes. Sony, and what was your reaction to the Minister in regard to that? Because this is now not prosecution only in regard to one matter, but all matters falling into the category of TRC cases. And then Ramita goes on to express his concerns in relation to Section 179 of the Constitution and the like, which I won't go into. Do you have any reason to dispute the evidence of Dr. Ramita on that exchange?
No, I have no reason to dispute what he said.
Then we'll also turn to Ramita's statement. And this is in Dr. Ramita's bundle at page 241, paragraph 32. And since it's not part of this bundle, I'm just going to read paragraph 32 into the record and you can respond. I advised Advocate Ackerman SC that it would be better to wait and have a better understanding of what exactly was happening. Shortly after I've spoken with Advocate Ackerman, I received a telephone call from the Minister of Justice, Mrs. Bridget Mabandlo. She told me that there is a task team which was appointed by the DG's forum to develop a mechanism to deal with TRC cases. I expressed to the Minister my concern that any process or mechanism which involves the executive or the justice and security cluster would amount to encroaching in prosecutorial decision-making and would be a violation of prosecutorial independence as enshrined in Section 179. The Minister nonetheless insisted that the prosecution of all TRC-related cases must be put on hold until the development and adoption of guidelines. Any reason to dispute that evidence?
I have no reason to dispute that, Commissioners.
Then let's move to the issue around the consultation with the Reverend Frank Chikani. Then you referred to the minutes of the final meeting of the task team on the 29th of January 2007. That's PCJ 11. We don't have to go there. It was put to you by my learned friend that if Ackerman had disclosed about the consultation earlier in January, I believe it was on the 22nd, then maybe that issue might have been resolved. And as I understand your response, you disagreed because the decision to prosecute had already been taken, and that wasn't going to be changed. So I wanted to suggest to you, or put it to you, that the real issue here had nothing to do with a consultation with the Reverend Frank Chikani, but the real issue of concern of the SAPs and others was in fact the decision of the NPA to proceed with that prosecution without waiting for the inputs from the DGs.
Yes, Commissioners, that is correct. I mean, so much is even conveyed in the letter that was written and signed by National Commissioner Silibe.
And so would I be right in saying that the issue of consultation, which has been highlighted left, right and center, is just a red herring?
Certainly, because he knew that Reverend Chikane had been consulted on several occasions, including an occasion when I met Reverend Chikane. And this was all in record. They knew.
And then lastly, let's turn to the question of the forgery. Ms. Ranto put it to you that the police had carried out a forensic investigation and had concluded that there was no forgery. Now, to be fair to you, you should know a bit more about the attempt to carry out an investigation by the NPA, since just weeks later you were suspended from the office of the NDPP. Are you aware that Ackerman and the NPA formally requested SAPS for the original memorandum in question? Were you aware that that request had been made?
No, I was not aware of that.
Yes. And then perhaps you also wouldn't be aware that the original memorandum was never provided to the NPA so they could carry out their own forensic investigation.
Well, that's what Councillor Ranto told me.
Yes. Well, that's the evidence of Ackerman, and in due course an argument we'll be pointing to the documents where the request was made, and the point was made by
Mr.
Ackerman.
Vani, where
Yes.
are you going with this line of re-examination?
The question I want to put to the witness is whether the withholding of the original memorandum was aimed at preventing the NPA from carrying out
How
their
would
own.
you know?
Well, just as a senior prosecutor, whether he has a view on that.
No,
Okay.
I will not allow it.
As the chairperson pleases. No further question, chairperson.
Thank you. Mr. Masugu,
Thank you, Chair.
let me start
Thank you,
by
Commissioner.
doing the housekeeping thing before we proceed. How long are you going to be with your cross-examination? I'm looking at the time now, it's 3:30.
Chair, I am hoping to be done by 4.
Thank you.
But as you would know, Chair, most of this depends also on what emerges in the course of engagement with the
Yes, you are only
witness.
as long as the answers you get from
Yes,
the witness.
yes.
Yes. That,
But my aim is
that-
4 o'clock.
That in mind, you aim to be finished by 4 o'clock.
Yes, I will.
Thank you.
Advocate Piccoli, finally we get to talk.
That's correct.
Yes. Most of the issues that you've been asked on are issues that I would have asked you, but now that they've been asked by my other colleagues, I will not deal with them. The questions I intend to ask relate to your understanding of what you call interference, or your understanding on what you call obstruction, and or hindrance, the kind of conduct that is envisaged in Section 32, 1B of the National Prosecuting Act. You're familiar with that
Yes.
provision, right?
Yes, I am, Commissioners. Thank you.
And you're also aware that that provision creates a criminal offense under Section 41 of the NPA Act.
That is correct.
In other words, if you allege that someone has conducted themselves in breach of that, of Section 31B, they're essentially exposing themselves to a criminal conduct or criminal liability under Section 41, right?
That is correct, Council.
Now, you would have assessed the conduct of your colleagues in the conduct of people you're engaging with as NTPP, the police, the DGs, the minister. You would have assessed that conduct within the eyes of your understanding of what was prohibited conduct in terms of Section 32(1)(b), right?
That is correct, Commissioners.
And you formed very strong views in real time of that conduct in certain instances, that the conduct was amounted to unlawful conduct, unconstitutional conduct. Am I right?
Yes, that time when I did feel like that I'm being frustrated.
And more precisely, in relation to the minister, you felt very strongly that some of her instructions bordered on unconstitutional conduct.
Which I made it plain to her. Yes.
Yes. And you also felt very strongly about Commissioner Slebe's views or conduct as well, that it bordered on a violation of the law, right?
Yes, I did have that strong feeling.
Yes. In fact, when you wrote to the minister a memo, the memo which really just crystallized how you felt at the time, you used very strong language.
I thought I was soft.
Yes. Yeah, well, you know, there's nothing softer about calling conduct unconstitutional. That's the highest bar one can get. Essentially, what you were talking about was conduct which was criminal.
Yes, that's why I didn't use criminal conduct, that it was bordering on criminal conduct.
Yes.
Yes.
But so that we extricate some of our clients from this conduct, you're not accusing Mr. Smelane of having interfered with your prosecutorial independence, right?
Well, I didn't see him playing an active role in trying to speak to the fellow DGs, because when he agreed to the letter, which was written by National Commissioner, and that I felt strongly about, and during this cross-examination I even referred to as a shocker, and he expressed agreement with the position that was taken by the National Commissioner. So in that sense, he would have been part of that.
So are you saying that you are accusing him of having interfered with your prosecutorial independence because he expressed a view in support of what the National Commissioner was saying?
Put it the other way, I would say that there's nothing that showed that he defended prosecutorial independence.
Okay. Now, can I just then, given the answer you've given,
If I may-
which is a bit, sorry.
So, if you allow me, just on the question of what Section 32 talks about in terms of obstructing, hindering, and improperly interfering. That obviously would have raised the bar in terms of what really constitutes that. And I didn't want to further cause more tensions, because if I felt that strongly, I could have, sort of caused an investigation to be properly carried out. To be fair on them, they never said I must stop, other than when they're saying that the decision to prosecute should wait for their recommendation.
Yes, I'm attracted to that proposition you're putting across, because then it helps us to define exactly what you found objectionable conduct by the DGs. And I want to take you to the letter of Mr. Slebe, which is on page 172 and 73 of the Kalata Bundle 2. Are you there?
Sorry, Commissioner. Yes, I'm the commissioners.
Right. So what is in that letter of Commissioner Slebe, the late Commissioner Slebe, that you found objectionable, was his view expressed more precisely in paragraph 3, where he says, I have insisted that the complaint be consulted in terms of the guidelines on the basis that the Director General will have an opportunity to provide input before a decision on a prosecution is taken. That was the first salvo, I suppose, for you, that there was a misunderstanding in the, am I wrong?
I had a serious problem with this, yes. I had a problem.
So I'm correct that this was a problem for you? I'm correct that this was a problem for you?
I had a problem with that.
Right. And then the next one would have been third paragraph from below, which says, although I do not insist on a meeting of the Directors Generals after each meeting of our officials, I deem it necessary that the substantive reports and recommendations of the officials should be discussed by the Directors General before a decision is made. Is that correct?
Yes, I have a problem with that as well.
Yeah.
Yeah.
And that is because you took the view that such a view fetters your discretion as a final arbiter of a prosecutorial decision.
Yes.
Yes. But a fair reading of the letter, Mr. Pikoli, in the context of your understanding of interagency collaboration, could also be that all that Commissioner Silebe was saying was that he has got these views and is putting them to you as views that you ought to consider. Why is that offensive?
No, because if he had those views, there's nothing that stopped either the task team or the Directors General from airing those views and putting them to me.
Yes, but
Yes.
even taking it that extent, that other DGs could have the same views that as the same views that Commissioner Slebe had, even taking as far as you have taken it, which is that he could influence other Director Generals to have the same views. Why is that view interference in the sense envisaged in Section 32(1)(b)?
You see, the problem I'm having is that one wouldn't have a situation where the decision of the NPA is second guessed by any other person outside of the NPA. It would have meant that even when we, as prosecutors, having assessed each case and we feel that we are ready to go on trial on the matter, then we have got to wait for somebody else outside of the NPA before we can take a decision. That cannot be right.
Yes. No, I accept. So he was expressing a view. He was not making a directive that's how he wanted you. He was not countermanding you from exercising your power. He was expressing a view. And you had liberty to take the view or not to take the liberty. Am I correct?
Before I respond to that, you go back to that paragraph. It says, he's
Sorry?
talking about, he's
Yes.
saying, I, as the National Commissioner of Police, insisted that the complainant be consulted. By this time, this is 2007, he was aware that the Reverend Chikane was consulted. There's no way in which he could have said that I didn't know that, because he was made aware to the task team, and also I made them aware in a meeting which I had with the DGs that I have spoken to Reverend Chikane. That's why we were able then to take a decision.
It's fair enough. I'll take it on what you say, that he was aware. And so you'd say he was aware and he was not being genuine when he expressed the view that he expressed in the letter. He was lying.
Commissioners, this is what I was saying as, delaying tactics, trying to kick the ball, to touch.
Yes, but he was not directing you not to take a decision. He was saying that he believed that consultations should take place. And if you felt that this was a lie, he was not saying, he had no power, no authority whatsoever, and you knew that. He had no authority, he had no power to stop you from pursuing any decision that you wanted to pursue.
Yeah.
As all of the other DGs, sorry.
Commissioners, my responses to that is that by the time he wrote this letter, he knew that there were consultations with the Reverend Chikane.
Yes.
Yes.
No, yes, I'm assuming, I'm accepting your version, and I'm putting to you that even at the level at which at your version that he knew. In other words, you're saying that in what is contained in that letter was a lie, because he was just being obstructionist, right?
Well, I would say he was obstructionist.
Yeah, but that view he held had absolutely no legal authority or no legal relevance to how you exercise your discretion.
Yeah, of course, it didn't stop him from making an attempt.
No. From what he said, you were not bound as NDPP with the powers you had to even regard it as anything to consider in making decisions.
Yes, I never regarded myself bound by any other decision taken elsewhere.
But I just want to take you to another point, which perhaps it's a point which I think is important to look at, because it gives a context in terms of what your obligations are when you receive recommendations, views, opinions of different people from anybody, including the DGs. Can I take you to section 22, subsection 4?
Yes.
Maybe
Yes.
because it's would it be okay if I just read it to you?
I'm pretty familiar.
You're pretty familiar with it, okay. So,
Read it nevertheless.
sorry?
Read it nevertheless.
Yes, thank you, Commissioner. The subsection 4 says, in addition to any other powers, duties, and functions conferred or imposed on or assigned to the National Director by Section 179 or any other provision of the Constitution, this Act or any other law, the National Director as the head of the prosecuting authority, and if we go to B, 4B, shall maintain close liaison with deputy directors, deputy national directors, the directors, the prosecutors, the legal professions, legal institutions, in order to foster common policies, practices, and to promote cooperation in relation to the handling of complaints in respect of the prosecuting authority.
Yeah.
Right.
I'm
So
familiar
you're expected to receive from a vast group of society, to collaborate with society and to collaborate with your team and others. Am I reading it correctly?
That is correct.
Okay.
Except to say that, no. If you read the entire section, 22, it also talks to representations being made by the accused person, and so forth and so forth, after that decision had been taken by the NPA, right? And then what follows there, I wish we could read that. It's a question now of complaints or allegations being made.
No, I understand. No, because I promised the chair that I want to get to 4. I want to go straight to the provision I would like a comment on, which I suggest you must hear me on, so that when you give the answer you want to give, you have at least the benefit of the view that I'm interested in your opinion, or at least I would like the commissions to have an interest in. And it says that you may consider, that's C, says you may consider the recommendations, suggestions, and requests concerning the prosecuting authority as he or she may receive from any source.
Yes.
Would that not cover the DGs themselves?
No, this does not talk about prosecutorial decisions. It talks about complaints. That falls under the subsection that deals with complaints and allegations being made.
Okay. No,
And here, we're not dealing with that.
no, I have a different view on the interpretation of and as both lawyers,
Lawyers
we
always
can differ on that. I think it's for the sake of argument.
Yes,
Can I proceed?
that's for argument,
Yes.
Mr. Masu.
Yes.
Yeah.
So then perhaps let me then come back to your view that what Commissioner Slebe was saying to you was offensive in terms of Section 32(1)(b). Am I correct that that's what you're saying?
Yeah, I felt that I was being made to await recommendations before taking a prosecutorial decision.
And you've accepted that if you formed that view and it was a genuinely held view, it would constitute a threat to your ability to act independently.
Perhaps let me put it this way. You know, prosecutors are open to receiving information, people making representations, and they are required in law to consider those representations. Right?
But I'm not asking that question.
He has not finished,
I'm not asking the question he's answering. I don't know what question he's answering.
but let him.
No.
yes.
No. The question, actually what you are saying is that the letter written by Silibe fell within the category of recommendations being made to the NPA and which we did not consider because they were never made. Isn't it?
No, I have not asked the question.
We had a
No.
statutory obligation
Yes.
to receive those
Advocate
recommendations.
Pikoli, allow him to answer the direct question first before you respond. Mr. Masugu, be pointed.
I think I have been pointed, Chair.
Yes.
Yeah, I think I want to ask other questions other than the question he's
Yes.
answering.
Yes, you may proceed.
Oh, okay. So Mr. Pikoli, if you formed a clear view that this conduct or the letter of Mr. Slebe or Commissioner Slebe, read together with Mrs. Melane's concurrence, or at least what he said in his own letter, amounted to a breach of Section 32(1)(b, that you'd have been under duty to point that out to them.
No.
Am I correct?
You see, well, firstly, I did say in my response that I don't agree with that, what they were saying, that what the National Commissioner was saying in his letter. I made it clear that I don't agree with that position.
Thanks.
And
You
following that, I raised that matter also with the minister
did. Right.
on this issue. And of course, prosecutors always exercise discretion, because if, for instance, I had wanted to cause an investigation which would have led to a prosecution as a result of what might have been a breach of Section 32, obviously it would have required a higher standard of proof, because now it's a criminal matter. And in my mind, and also given the fact that, look, this is a situation which we can deal with without having to take each other to court on these matters.
Yes,
and that was my view. If you ask me, the question is, why did I not charge them? Because the law made provision for that. Because it says any improper interference, hindrance, or obstruction by any organ of state or any other person, it becomes a criminal offense. It criminalizes that type of offense. But again, it's a matter which have required a higher standard of proof.
yes, so
my preoccupation at the time was to go ahead with this matter, because I felt that even if they're making an attempt to try and interfere, I'm not going to acquiesce to that. I'm not going to submit to that. That I'm going to go ahead, and they are not going to stop me. So I felt that, I didn't see it as a real threat, because I would have proceeded nonetheless, as we did.
Yes. The problem with that approach, if you have taken the view that this is a violation of Section 32(1), is that this is a very serious offense. it carries a sentence of, upon conviction, a sentence of not exceeding 10 years.
You can hang me for that. You can hang me for that.
No, I would
For
never
not,
do that.
for not having acted.
Yes, because I take the view that your response to this letter was over the top. Because a mere disagreement, as you asserted to to Commissioner Slebe, and perhaps by extension to Advocate Smelane, by extension was sufficient to deal with it. It was not interference in the sense envisaged in Section 32, 1B. A mere disagreement with them over their views, over their proposal recommendations, does not violate the law.
You know, delaying a process where the NPA had taken a decision to prosecute by raising things that he knew were addressed is frustrating the carrying out of that prosecutorial mandate.
And the way to deal with it, Advocate Piccoli, in your position as NTP, was simply to disagree with them. To say, I'm not going to follow your proposals, or I disagree with your recommendations. That would have been sufficient, as it was. Because this is the problem. If you took the view that this was a criminal interference with a lawful process, you would have been under a duty to trigger a criminal response to it.
Actually, you know, for me, you know, when I make reference to a political interference, the DGs could have been used as a tool. But political interference is a result of the conduct of the executive authorities, which could manifest itself in the form of what the DGs then were doing, who were delaying deliberately the process of going ahead with the prosecutions.
So can I just...
And the point that I'm making is that the problem I'm having with political interference is more on the side of the executive authority.
Yes, I understand that, Mr. Piccoli, but just so the commission gets the evidence correctly, your response to what you regarded as an obstruction, as a interference or an improper interference, was not to lodge a written objection that would trigger a criminal process. Instead, to report the same people to the member of the executive, right?
Can you come again?
So your response to Commissioner Slebe's letter was to write a memorandum to the minister.
Yes.
Right. But that was not the only, in fact, that was not the most effective way of protecting what you regarded as an assault on your prosecutorial independence. You did not lodge a formal objection to Mr. Slebe, point out to them that they were now violating a law for which there are criminal sanctions.
That's why I said that you could hang me on that, because perhaps I could have done that.
No,
and I didn't do it.
No, that's fine. And I'm trying to suggest to you that you did not put it because you were aware that this was did not rise to the level of a criminal interference.
What I'm saying is that it would have required more investigations.
Okay. So we know that you did not seek any judicial intervention, you did not institute any internal processes that could have resulted in Mr. Smelane's DG being disciplined for this interference that you had alleged, or that would have resulted in Mr. Slebe being disciplined for that interference.
Well, look, doing the work of government doesn't necessarily mean that if you disagree with people, you'd want them to be punished for any reason. You just accept that, you know, this is what it's doing. The intention is not to punish. The intention was to carry out the mandate of the NPA.
No, but you are under a duty now because you are the NTPP. You are under a legal duty. It's no longer your wishes. It's no longer it's not your moral authority that's speaking. It's now your legal authority that is speaking. You are speaking from a position of authority that is mandated by law. When someone has violated the law, you react. And I mean, this Commission of Inquiry says stopped investigation. That's a serious charge. Yes.
Okay, thanks, Commissioners. I'm sure the council is aware that it's not in all cases where the NPA will mount a prosecution, even in cases which would demand that. That's what is called prosecutorial discretion. I might not have exercised in the manner you'd have wanted to.
Okay. Now, I think I'll leave that because I think I might. Can I have a bit more time, Chair, because it's now almost 4 o'clock.
How much time do you need?
Will you say yes or no? I mean, if he says yes or no to my questions,
Yes.
then,
No,
then maybe 15, 20 minutes.
No, the nature of
20
issues does not
minutes is
allow
too
for
much.
yes or
We
no.
still have another person to cross-examine Advocate Pikoli for the day.
Chair, the issues I'm trying to follow on the cross-examination of Mr. Pikoli have a direct impact on my client's
Yes, I
reputation.
understand that.
And given that he's an advocate, Chair, you would appreciate that if anything is suggested that he committed a criminal act, that's very serious. And I would like the indulgence of the Chair to...
Yes, you will
And-
have
and
an
it-
indulgence of 10 minutes.
Okay, I'll try my best. Now I will have to... I want to suggest, to make a closing remark regarding your allegation that the conduct of the DGs was open to a discretion not to prosecute, because if the allegation was that they were interfering with a legal process of prosecution, that was fundamental to the mandate of the NPA, and you would have been obliged to take very strong action. The fact that you did not do so suggests that even in your own assessment of that conduct, these conduct are simply rose to the level of mere disagreements. Different approaches to collaboration, interagency collaboration, had nothing to do with them trying to take away your powers or trying to interfere with your prosecutorial decisions.
No, sorry, Commissioners. No, given all that has transpired from 2005 to 2007 was a process being frustrated, a process which was meant to culminate in prosecutions. And the DGs of the cluster played a role in ensuring that the process is being frustrated.
And I'm suggesting to you that you had the power to unfrustrate that process lie in your hands, and you did not exercise that power. And that can only be explained by just an assessment of the facts, which objectively looked at points to disagreements in approaches, but unfettered in your ability to exercise your discretion.
I don't think I can take it any further, Commissioners, other than to say that them frustrating the process amounted to interfering with the prosecutorial decision.
And then I want to take you to the allegations that are made by yourself and Mr. Ackerman, Advocate Ackerman, SC, about Mr. Smelane. Did you regard that meeting that you had with him, in which he indicated to you that he requested that you avail yourself to a meeting with the cluster to deal with the issue of Mr. Ackerman, and when he told you that the meeting's interest is really to look at whether you could remove Mr. Ackerman from the TRC cases. That was interference.
My recollection of my meeting, which was in my office with Advocate Simelane, there was no indication of him extending an invitation to attend a meeting of DGs. What Advocate Simelane was saying in that meeting was to remove Advocate Ackerman as a prosecutor in the TRC cases.
Can I ask this? Is that the only meeting you had where the removal of Mr. Ackerman was discussed?
No,
There was another meeting.
there was another meeting.
Okay. Mr. Smelane's version, as you would know, is that he was tasked by the cluster to request a meeting with you for
Well-
purposes of discussing the issue of Ackerman. He arranged that meeting with you at your office. And you're correct that you met at his office.
Yes.
And in the office, he said, look, the DGs, or the cluster would like to meet with you. I'm telling you what his version is.
Yeah.
The cluster would like to meet with you. And as a heads up, this is what they would like to discuss, the removal of Ackerman. And your response was, there is no way I'm doing it.
Yes,
There's no way I'm not removing Mr. Ackerman.
that's correct.
And you subsequently informed everybody else that you're not doing so. In a subsequent meeting.
In a subsequent meeting,
Right.
that is correct.
So the version of Mrs. Melane of how he met you, and you would accept that Mrs. Melane would not, as an advocate, would not have met you to come and tell you to remove Ackerman. He had no authority to do that.
Well, I suppose he was asked by the DGs to come and tell me to remove
Yes.
Ackerman.
No, so he's, and I think there's a slight recollection of events, because his version is that he was telling you what the meeting that they were requesting would ask you to do. He was giving a heads up of what the meeting was about.
Well, if that's the version that he has given you, that's the version that he has given you. But I'm
Yes.
saying our discussions didn't extend to the question of me being invited to a meeting of DGs to discuss the removal of Ackerman.
But Mr. Piccoli, you subsequently had a meeting with DGs.
The meeting did take place, yes.
Yes. And in that
It was
meeting,
not as a result of that meeting. It could have been a result of the meeting because I refused there. Then there was the other meeting. Not that he had gone specifically to request me to attend a meeting of DGs.
no,
Because when he came to me, he didn't say that he was requested to ask a meeting with the DGs.
yes. No, Mr. Piccoli, I think perhaps let me put it this way to you. I'm sure you and Mr. Smelane have mutual respect.
Yes, we do.
And you were at mutual respect then when you was DG and you were NDPP, and you still have mutual respect even now.
That is correct.
You extend to Mr. Smelane the presumption of integrity. Am I correct?
Well, it's expected of him to be a person of integrity.
Right. It's not my
Like it is
question,
expected
but
of
I
me.
understand what
Like
I
it is
understand your
expected
answer.
of me to be a person of integrity.
Yeah, it does.
Yes.
Yeah, it does. But so in that line, why do you think Mr. Smelane, as DG with no authority whatsoever, would walk into your office and ask you to remove an employee? Why would he do that?
Well, easily. If it's something that they, as DGs, they had discussed and might have been mandated by the DGs to raise the matter with me, my office was always open to him.
Okay. Obviously, there is a difference of opinion on what took place in that meeting. It was not a minuted meeting. It's a meeting that is based on
It was a one-on-one.
on your recollection. But here's the issue. You then had a subsequent meeting where DGs raised the same issue.
Yes, that's correct.
which is what Mr. Smelane said they would raise.
This is I'm
In his
saying-
version. I'm saying in his version.
No. What I'm saying is that he didn't raise that I was requested to attend a meeting of DGs, and this is what they would raise. That he was giving me a heads up.
No, I accept that.
The
That's your
discussions
version.
that I had with him were around the removal of Advocate Akaba. The
No,
fact
I-
that there was a subsequent meeting does not mean that he had gone there to request
No.
that meeting.
Fine, I accept that that's your version. His version is different. His version is that he asked you for a meeting, he told you what the meeting would be about, and you made it clear that in that meeting you would tell whoever wants to removal of Ackerman that it won't happen. Subsequent to that meeting, there was a meeting with the DGs in which you expressed exactly that view.
What is the question, Mr. Masugo?
It's a version I'm putting to him,
Yes.
Chair.
Yes.
Yeah.
And I think I've put my version of that meeting.
Yes, no, what I'm wanting you to accept is that in the subsequent meeting, the issue of the removal of Mr. Ackerman was discussed. You said the same thing that you told Mrs. Melane.
Yes, that was never in dispute.
Yes. So your only difference with Mrs. Melane is that you think Mrs. Melane came to your office in order to instruct you to remove Ackerman.
I don't think that was the nature of our discussions.
Yeah, because you know he can't do that.
No.
He would not do it because it's not lawful for him to do that. You know that, Mr. Pikwati. Why would you say that?
The
Mr.
commissioners-
Masugo, I think that's argumentative.
I'm talking about what happened in my meeting. With
Your
Advocate
recollection
Sibelane.
of it, not what happened. It's your
My
recollection.
Masugo,
version,
I've
as much as
already
he has
ruled.
got his version.
I've already ruled on this matter.
Sorry, Chair, what is the ruling?
I think it's argumentative, what you are putting to the.
No, Chair. It's very important to also put a version of my client.
Well, he's already
to-
responded to that version.
Yes,
that
and I'm
he has a
challenging his
different-
version.
he
I'm
has a
challenging his
different-
version of what he's
Yes.
saying happened.
Yes. I mean, where is that going to take us?
Okay.
When he has already given his own version.
So there's also a discussion or debate about whether or not you, in the meeting where you subsequently, you say you refused to remove Mr. Ackerman, but you took a strategic decision because your evidence is that you said to the DGs, or when you're giving evidence here, you said, I had to choose my battles. And so I decided that Dr. Ramaite would lead the TRC cases.
Going back to my evidence in chief, you are right when I said that I decided to choose my battles commissioners. I even added that for me it was a question of tactical flexibility. Those are the words that I used in my evidence in chief. That then I said Dr. Ramaite is going to chair those meetings.
No, you did not say he's going to chair those meetings, Mr. Pekwale, because I will show you now that you actually said he was going to lead. And that would be in Bangle.
May I say something? Even if I said lead, the question was about removing as a prosecutor Advocate Ackerman, which thing I refused to remove him as a prosecutor in those matters because he was appointed via a presidential proclamation to be the head of the PCLU. And the function, then we would have then altered his conditions of service if the question of the TRC prosecutions were taken out of that portfolio. Because he was the special director appointed, amongst other things, to deal with post-TRC prosecutions.
Can I take you to page 114, PCJ1 in Bangle 2? page 114, the annex is PCJ1, and it's in the bundle 2, the Piccoli bundle. It's, yeah.
Whilst waiting, Commissioners, if you allow me, some of the minutes will reflect that Advocate Ackerman continued to participate in those task teams, where he actually even talks about a decision that was taken to prosecute. Yes,
You got the
I'm
letter?
there, Counsel. Yes.
Yes, you see, PCJ1 on page 114 is a letter from you, is that correct?
Yes, the letter to Commissioner Selibe.
And it was addressed to Commissioner Slebe.
Yes.
And if you read that
1910,
letter,
2006.
yes. I will go straight to where you, paragraph 3 of that letter says, I have appointed Dr. Silas Ramaite to head and supervise the prosecution processes of all TRC related matters.
Actually, this was restating the position of Dr. Ramaite because the PCLU resulted under him. And here I'm saying to head and supervise the prosecution, meaning that he's not the one who was going to do the prosecutions. The unit itself will continue doing the prosecutions.
No, because what the DGs wanted, what they were complaining about, was Mr. Ackerman being the head of the, being the head and supervisor of prosecution of all TRC cases. Am I wrong?
This is what I'm saying. This was just merely a restatement of the position already occupied by Dr. Ramaite, because the PCLU
No, I hear you.
already resorted under him. So it's just a restatement.
No, Mr. Piccoli. The complaint by DGs was what? In relation to Ackerman?
They wanted him removed as
From
a
where?
prosecutor in the TRC cases.
No, that's not how the issue was raised. The issue, as Mrs. Melan's testimony, is that what was asked of was that he should not be the face of the TRC cases. Not the face. In other words, it was the leadership, the headship of, or the supervisory position that they were concerned about. Not the fact that it was prosecution.
Advocate Ackerman, during my time, remained the head of the PCLU. And being the face of the PCLU meant that he was the face of post-TRC prosecutions.
Here is a letter.
And that never changed.
But here is a letter.
Of what significance is it?
Paragraph 3, Mr.
No.
Can I read? Sorry, can I read it?
Sorry, Commissioner.
Can I read paragraph 3?
Can I read it
You
myself?
asked me a question, so I'm responding to your question. Can I answer the question?
Yes, I'm
Yeah.
sorry.
Paragraph 3 says, I have appointed Dr. Silas Ramaite to head and supervise the prosecution process of all TRC cases. All TRC cases.
TRC related matters.
TRC related matters.
Yes. You see, Commissioners, if I may respond, up until this point, the person who was engaging on TRC matters, it was Advocate Ackerman. And given his style, he's got a robust style, and he can be very blunt. And to make sure that the process goes ahead, I felt that if we have got then Dr. Ramaite attending those meetings, he'll be able then to deflect attention away from Ackerman, because then now he'll be the one who will be in charge, who will make it clear that Dr. Ackerman, Advocate Ackerman, falls under him. So that's why then Dr. Ramayite ended up chairing those meetings, so that it's not Advocate Ackerman who is, seen to be in charge of the post-TRC matters. And it's a matter which, that's how it was, anyway.
And then perhaps, I know I'm treading on thin ice right now.
You are.
Yes. Can I just ask the last few series of questions? They are just like boom, 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 boom.
I mean, what do you mean by boom, boom, boom?
Like
I've been-
one, two, without.
How many questions do you want to put to the witness?
Chair, it's not an ideal way to conduct a cross-examination with such an important client.
No, all clients are important when it comes to
No,
cross-examination.
my particular client is important to me.
Yes,
And I should be.
like all counsel who are here are representing important clients. So yours is not out of the ordinary.
Okay, how do I handle this now?
Yes, Mr. Masuku? Boom, boom, boom.
Yeah, just for just the meeting you concede that happened between yourself and the DGs.
I didn't concede. It's a meeting that took place, which I never denied.
No, Mr. Piccoli, I don't want to go there because.
No, let's go there if needs
No,
be.
I don't want to go there because then this boom boom won't work. Because I'll put it this way: you would have told you'd have consulted with Mr. Vani, and there are meetings that you deny took place. I'm not going there because it's clear that the meeting took place between yourself and the DGs, where Ackerman was a discussion. So I'm interested in that. I'm no longer interested in the theory of whether you attended a meeting or not, which was original concern. I'm now interested in a question relating to the meeting that took place, which you agreed took place with the DGs.
Which was I had, which
Who
meeting
called
is
that meeting, Mr. Piccoli?
There was a meeting which was convened, which was at the NPA offices. There were meetings, I think about 2, which were held at the presidency, the West Wing, which I attended.
No, but
So
who
I
called the
want you
meeting?
to know which one.
I'm calling. It was specific. Who called the meeting in which you specifically dealt with the issue of Mr. Ackerman?
I don't know who called the meeting.
It was Mr. Smelane.
It was, well,
Yes.
if it was, must be so.
Yes. So
Yes.
So that's very important to note. The last thing. Can I take you to, you're still on the same page where we were talking about the letter of Mr. You responded to that letter.
No, I'm not there because I'm where
Okay, in page
I
174.
wrote to the National Commissioner Silebe,
Yes, so
which is
Silebe wrote a
which
letter
is
to you.
PCJ1.
Yes, page 172. So that your response to the letter of Mrs. Slebe is 174.
174 page. Is it a page?
It's
174.
page 174. And the Galata bundle. Your bundle 2, sorry.
Page 174, I've got my response to Commissioner Silibe
So it was on the 7th.
on the 6th.
Okay, it was on the 6th of February.
That's correct.
That's the same day that you'd received Selebe's letter.
Yes.
Then Mr. Smelane replied, responded to Selebe's in 174.1. And that was on the,
Where's Advocate Simelane's response?
it's 174.1.
No, 174 is mine. 1741.
Point 1,
Yes.
right? And it was also on the 7th of,
Not also on the 7th, because this was on the 6th, and then,
sorry, it was on the 6th, on the
Yeah.
7th, yes. This was
So
next
it was
day,
on the
when you had already responded.
yeah.
And this letter was addressed to Silebe. Do you remember how you received Mr. Smelane's letter?
No, I don't.
Okay. And then he also proposed that as most of the Director General will be in Cape Town, that's the last sentence, the meeting should take place there tomorrow, Friday, 9 February 2027. That meeting did not take place, right?
Yeah, I have no recollection of that meeting.
Right. But what then happened is that you then on this 15th of February 2007, you addressed a memo to the minister.
Yeah,
That's
that
the,
long,
that's the big memo that,
yeah, that long memo. Yeah.
that long memo, yeah. And you addressed that memo without having had any meeting with either Slebe or Mr. Smelane.
Yes, that's correct.
Yeah. So whatever proposals they made there had not been written to you, they had not been concretized, they had not been firmed up, you just didn't like them.
What proposal? Other than the letter?
Yes, what was contained in the letter, you didn't like what was contained in the letter of Slebe and supported by Mrs. Melanie.
Yes.
Yeah. But there was no meeting with you in order for them to put their proposals, the details of their proposal, and to hear from you what your response is.
No, you know, without sounding arrogant, but I didn't see any point of continuing, you know, on the same old matters that we have traversed over a long period of time, where you agreed that we'll disagree on the matters. Because I didn't see that anything new would come out.
Yes. But the letter, the memorandum to the minister was wholly unhelpful to resolve the problem that you believe you had identified. Because
Well,
the
in
minister,
fact,
sorry, can I just finish here?
Sorry.
Because the minister could only deal with Mr. Smelane, but you didn't mention Mr. Smelane in the letter, in the memorandum. It could not deal with Commissioner Slebe.
I don't recall even mentioning by name, but I mentioned DGs.
Yes.
And Advocate Milane would have been part of the DGs.
But there is no process whatsoever that you were trying to trigger that would have resolved what you regarded as a stoppage of prosecutions and investigations of TRC-related matters.
Thanks, Commissioners. That's exactly why I wrote to the minister, because suppose had the minister responded, then that would have kicked off the process that you are suggesting.
Can I say the last thing? But that's a very, very, very revealing response, that you believe that your ability to investigate and prosecute matters hinged on the minister's response and not on you.
No, you are reading me incorrectly.
Perhaps your answer should be different to what you've given.
No, what I'm saying, I put out the chronology of events. I laid out the challenges that the process was faced with. I did indicate that I felt that I'm being impeded in the carrying out of my functions. And I made reference also when Council Ranto was asking me on the same issue. I made reference to the last paragraph of my letter, which was a sign of desperation and frustration about the process.
Yes. That's, perhaps I should just leave it for argument. We'll argue that you didn't have to be desperate because you were armed and dangerous in terms of the law. And if you really wanted to deal with this problem that you were facing, which had trapped you in inactivity, to be dealt with properly, you had the powers in your hands to deal with it as firmly as you did. By referring the complaint to the minister, you're essentially relying on the same institution you are accusing of being obstructive of your work. And it was an unhelpful response. That's what we'll argue.
Well, I will leave it to the legal argument. But
Thank you.
But
That's all.
I would want, please, commissioners, I don't want to leave that. You see, I was never given an opportunity to deal with these matters. Because immediately after the Section 105A trial, I was gone. I was gone. You don't know how I would have reacted had I remained. In terms of what I felt was an improper interference. Yes, at the time, I didn't want to mess up with things. There were so many things that were happening, so many irons in the fire, including a case that involved the late Commissioner Silebe, the case involving Mr. Zuma. There were so many irons in the fire at the time. So I had to be selective as to how I intended dealing with all those matters. But the rest is history. After the 23rd of September, I was no longer in the office.
Chair,
Any other thing would be speculation.
Chair, there are many other questions I would have liked, but I will respect the fact that there is a bit more that has to be done by other witnesses. I think for purposes of of what I intend to argue at the end, I think this would be the end of it. Although I'd have liked a bit more questions, but it's fine. We can forego that.
Okay, thank you, Mr. Masugu. Ms. Ntoko?
No, Mr.
Oh, Mr. Vani, sorry.
Thank you, Chair, for the indulgence. Just a few questions by way of re-exam. In your cross by my learned friend, Mr. Simelani, much about the conduct of the late Commissioner Selebi was raised. And questions around whether he had violated the law or not. I want to draw your attention to an exchange you had with Mr. Selebi, and this is in your bundle 2 at page 24. This is your 2015 statement. I want to refer you to paragraph 62 on paginated page 24.
I'm there, commissioners.
So you make reference to a meeting of the Justice, Crime Prevention and Security Cabinet Cluster on post-TRC matters, which was held on 23rd August 2007, and this was shortly after the I believe it was the report article was published. And you mentioned that it was attended by several cabinet ministers, DGs, including Mr. Selebi. Ministers included National Intelligence Services Minister Ronnie Kasrils, Minister Mabandla, Minister Skuyia, and others. Now, if you look at at least paragraph 63, you mentioned that during this meeting, Salebi said to me that the gloves are now off and that he was declaring war on you. So here you have a high-level meeting with ministers and DGs present, and the chief of police says that he is declaring war on you. How did you take that conduct of the commissioner in a meeting like that, indicating that he has now declared war on you?
Yeah, thank you, commissioners. Obviously, that's not what one would expect from a colleague. But also, it was an indicator of what to expect. But also, it was like intimidation, wanting me to back off, because it was also after I had given the instruction that they must investigate the origins of the origins of the letter that appeared in the BLD, where SABC members were implicated for having forged that letter. And it was after the Minister of Justice, yes, at the time, Mrs. Mabandla also was telling me to stop that investigation. Unfortunately, I was never intimidated by what he said, given my response to him, that for once in his life, he must just tell the truth and shame the devil, because I was fed up with all the lies that he was feeding to the ministers. I'm sorry to use that strong language.
Let's move on, Advocate Pekuli. And if we can turn to questions that were put to you in relation to Salebi's letter to you and the other DGs on the 6th of February 2007. And my learned friend suggested to you that you should simply have waited to hear the views of Mr. Salebi and the others. And as I understand your evidence, you pointed out that Mr. Chikani had already been consulted with, Mr. Salebi and the others had already put their views, but they were still insisting that you wait. Now, this process was a process that you had signed up to in good faith, that you had particularly rejected the two-stage process, that you couldn't act before hearing from these executive members. And now this two-stage process was being reintroduced, and not just by any officials. We're talking about some of the most powerful individuals in government at the time. The head of police, the head of NIA, and the head of the Department of Justice. Were you not justified in taking their approach seriously, given the positions they occupied?
What's the question?
So the question is, they were effectively trying to reintroduce the two-stage process, and these were not just any officials. They were head of the police, head of intelligence services, head of Department of Justice. You had to take that seriously, did you not?
I mean, it was just rehashing something that was long rejected, what was referred to as this two-stage process of making recommendations before the NPA can take a prosecutorial decision. So it was just rehashing, all those things. That's why I felt fed up of it.
Mr. Masuku has put it to you that because you did not prosecute Commissioner Salebi and others, that therefore there was no frustrating of your work, no interference or obstruction, because if there was, you would have prosecuted. And as I understand your evidence, Mr. Pikoli, you've pointed out that you don't prosecute in each and every case. But here you raised the matter with the minister. You expressed your disagreement directly with them. And given that prosecutions are based on a very high standard of proof, you didn't feel that was appropriate. Now, am I right in saying that you took an additional step as well? That you raised your concerns before a parliamentary portfolio committee on justice, and that, Commissioners, we make reference to the meeting held, I believe it was 3rd of March 2007, and it's in your bundle too, Mr. Pikoli, at page 178.
178.
Yes. In fact, the date of the meeting is the 3rd of May 2007. And perhaps just let me read a quote from the minutes.
I'm sorry, Commissioners, just to be clear, is the Parliamentary Monitoring Group, which starts 175.
Yes, it's that group that put together these minutes, but
Yes.
it was a meeting of the Justice and Constitutional Development Committee of Parliament, 3 May 2007. And if you turn to paginated page 178,
And my copy is very faint.
yes, it is quite faint and it's really tiny, and I might struggle to read it, but I'm going to try. Questions were raised around the TRC cases, and the following is said in the second paragraph at the top of the page. Advocate Vusi Pikoli, NDPP, added that this was a politically sensitive issue. The legal process must solve the problem. Whenever there was an attempt to charge members of the former police, there was political intervention, and effectively the NPA was being held to ransom by the former generals. So aside from raising your concerns with the minister, am I right in saying you were also raising the alarm before the Justice Portfolio Committee?
Yes, because that was part of our duty to report to Parliament on the work done by the NPA, and also in particular on the work of on the post-TRC matters.
And you explained further that these different events should not be seen in isolation, but the process of pursuing the TRC cases was being frustrated. Now, there's evidence before this commission that post the Chikani matter, in which a plea and sentence agreement was struck in August of 2007, and we know that not long after that case, you were suspended.
That is correct.
And also not long after that case, Ackerman was removed from his duties in relation to the TRC cases. But then there proceeded a period of nearly 10 years in which there wasn't a single prosecution, or for that matter, a TRC-related inquest. In your view, the failure to pursue cases for a 10-year period following the Chikani case, is that unconnected to the frustrations that you experienced at that time?
Thanks, Commissioners. Well, I wouldn't know what actually happened at the NPA on these matters because I was no longer there. But obviously the point I would want to make is that one, at the Ginoa Commission, this was one of the charges that I faced, my insistence on post-TRC prosecutions. Now, if you are a government that was willing to have these matters going to court, I would still want to know as to why was I then charged at the Ginoa Commission with that. That would be one issue. And then also, you know, having been suspended after having pursued this matter, was sending a chilling message to anyone who would have followed as the NTPP, whether in an acting capacity or as a permanent appointment. It was sending that signal that you continue doing what Pikoli did, you are going to be Pikolied. That is to get the same treatment that I got from government. That could have been the message that was being sent, but I don't want to speculate further and say what actually happened, because I don't know what actually happened. But facts speak for themselves, that until such time that the family of Nokuthula Simelane started raising all these issues, we start seeing movement much later. That's all I can say, Commissioners.
No further questions, Chairperson.
Thank you, Mr. Vani. Ms. Ntloko, it's 4:45.
Yes, Chair.
How long do you think you will be with your cross-examination, ma'am?
I think that's one of the most interesting questions one can ask in cross-examination. But I think most of my questions have been answered and asked, so I have tried to limit it as far as possible. I am hoping if we have to stay any longer, it would be 5 minutes extra.
5 minutes extra.
And of course, this is on the caveat that the witness answers the question that is being asked.
You are only as long as the answers you get from a witness. I'm aware of that.
Yes.
Yes, you may proceed, ma'am.
Thank you so much. I'm hoping you can see me from where I am sitting. I've never sat where you are.
Yes, I can see you,
Okay,
Council.
this is perfect. So I think we can start at your time in the DG's forum, and as I've indicated, most of the questions have been answered. You testified, and this is really, most of them are clarification in their very nature. You testified that you were the co-chair of that forum, is that correct?
The JCPS cluster.
Just GCPS cluster
That
of
is correct.
Directors
I
General.
was a co-chair.
Yes, okay. And you participated in the functioning of this forum, is that correct?
I participated in what?
In the functions of this forum at all times?
Of the cluster?
Yes.
Yes,
Okay.
that's correct.
And during your tenure, and this is the cluster of the DG's forum, we should be clear, is that correct?
That was tasked with implementing what the president raised in 2003. Or is it the general work of the cluster?
The general work of the cluster?
Yes.
Yes. And this is just to establish some ground rules on this. Then during your tenure on this DG's forum, and when it was established and operating, can we accept that at no time did you regard its work as improper interference?
Yes, that is quite clear from my evidence in chief.
No, I just
I
wanted to
actually
make-
supported the work.
Yes. Now, I think we can then move on to what I think should also not be contentious, which is the law. I'll be using Advocate Simelani's bundle. We thought there was just too many bundles. One just doesn't need to add to them. On that bundle, there's the constitutional provisions. You find them on page 7 of the bundle. Thank you to the gentleman assisting. So we'll start with section 179(1)(a). Of course, you can read it, but I'll just be putting the propositions to you. We can accept that the Constitution establishes a single national prosecuting authority headed by the NDPP and appointed by the President. Is that correct?
Yes.
Yes. And then section 179(2) provides that the prosecuting authority has the power to institute criminal proceedings on behalf of the state. Do you accept that this is then a power vested in the NDPP because section 1 indicates who is responsible for the National Prosecuting Authority?
Yes.
And then moving on to section 179(4), which provides for national legislation. We can agree that the national legislation envisaged there became the NPA Act, correct?
Yes.
Yes. And then moving again to section 179(5)(a), which indicates, and I'm going to read this one for the record, the NDPP must determine with the concurrence of the cabinet member responsible for the administration of justice, and after consulting the directors of public prosecutions, the prosecution policy. So can we accept that section 179 provides, well, the cabinet member that is envisaged there would be the minister?
Yes, that's correct.
Yes. And then section 179(6) provides that the cabinet member responsible for the administration of justice must exercise final responsibility over the prosecution authority. Now, I think we can accept, this was your evidence on the 13th of March, 2026. This is in pages 75, lines 3 to 4. I'm not sure if you have the transcript. You accepted that the minister exercised the final responsibility over the NPA under section 179(6). This is still correct?
That is correct.
Yeah. So we then accept that these are the legal provisions in relation to the Constitution. We accept that this is the law.
Yeah, that's what the Constitution says, and some of it are further explained or expanded in the Act itself. That's
Yes,
correct?
we go directly to the Act, in fact. Now, if we can use the Simelane bundle again, if we can look at pages 10 of that bundle, the preamble. The preamble to this Act reads as follows, and that would be paragraphs 4. It reads as follows, and whereas the Constitution provides that the National Director of Public Prosecutions must determine, with the concurrence of the Cabinet Minister responsible for the administration of justice, and after consulting the Directors of Public Prosecution, prosecution policy, which must be observed in the prosecution process. We agreed that this is what the Act indicates, correct?
That is correct. It's a restatement of 5A of the Constitution.
Yes. And then we move to sections 21. 21.
Yes.
That would be in the Simelane bundle as well. The difficulty I'm having is that I can't interfere with these mics, and so I keep having to turn my back. I think I've found a way to do it now. So going to section 21 of the Act. Again, section 21(1) of the Act restates the proposition of the prosecution policy, and in fact the heading says prosecution policy and issuing of policy directives. And it reads, the National Director shall, in accordance with section 179(5)(a) and (b), and any other relevant section of the Constitution, with the concurrence of the minister and after consulting the directors, determine prosecution policy and issue policy directives. And then the rest continues. We still agree that this is the law.
That is correct, Commissioners.
And then we now move to sections 22. Section 22(1) of the NPA Act provides that the National Director shall have authority over the exercising of all the powers and the performance of all the duties and functions conferred or imposed or assigned to any member of the prosecuting authority by the Constitution, this Act, and any other law. Do you accept that the NDPP then bears the ultimate responsibility of the NPA?
That is correct.
Do you accept that under the NPA Act and the Constitution, the NDPP has the sole and exclusive power to decide whether or not to prosecute within the context of the law that we've now read?
Did you say the NDPP?
Well, the NPA,
The NPA?
yes,
Yeah.
which is then the NDPP would have the authority and the power to, in fact, foresee all of those, to look into all of those decisions as the ultimate authority.
That is correct.
Okay, and then still working in the Act itself. If we go to section 32, and I think my learned senior, Masuku, had taken you through that particular provision, which is section 32(1)(b. And you had indicated you were quite familiar with it,
Yes.
which is subject to the Constitution and this Act, no organ of state and no member or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof. Then if we go to section 41, this is in page 27 of the Masuku bundle. Section 41(1) says, any person who contravenes with the provisions of section 32(1)(b shall be guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 2 years or both. But the point of it is that shall be guilty of an offense. We agree that is the law.
Yes.
So as an NDPP, and this is canvassed, this is the law, we have agreed on a few principles. The NDPP exercises the final power on the prosecution. The NDPP is the head of the NPA. The NDPP has all the powers in the Constitution and the NPA Act. Would we then agree that there is in fact then a duty on an NDPP who becomes aware of any alleged interference, not to permit such interference, and in fact to act in terms of this act, of the NPA Act? Because it doesn't say it may. It says who contravenes shall be guilty.
Yes, that presupposes a proper process
Yes.
of instituting investigations and proper institution of prosecutions. And that is the court's verdict.
But it also presupposes that if there is interference or there is perceived interference, the person who is perceiving the interference needs to do something about it. In fact, to ensure that this,
Yes.
the offense itself is thoroughly prosecuted.
Yes, the commissioner has also the power that the national director has, includes the power to prosecute or not to prosecute. It's also a statutory power
Yes.
conferred on the
On the NDPP
yes,
itself.
Yes.
And therefore, on that very statutory power, if we can then ask the question, why was that power not exercised in relation to what we now have called, well, the Tsalate group have called interference, political interference in this particular case?
Yes. I thought I did try to explain this thing.
I
because,
also thought so.
So did I.
Commissioners?
I thought, Ms. Ntloko, you would not traverse the issues that have already been traversed by your colleagues.
Chair, the question here is very different. Here,
Yes, how
the
different
witness
is it?
says, I, as the NDPP, had not only what the Act requires, because this question was not fully answered when Mr. Masuku actually asked it. He asked the question, and then there was a bit of, let me not call it what I want to call it, but there was a bit of, I'll call it commotion, but there's a different word I would have liked to use. But here, he has answered thoroughly. This is the law. This is what is required of an NDPP. And he even says himself, as the NDPP, I had the power to prosecute. Here we're sitting in a commission where we are told there was interference. And it's termed political interference. So it's either, then I can put the question differently, but the answer to it will be one of two things. And I can put it now. It's either the witness did not...
ask your question without having to give answers.
Okay, so then if we can then get back to saying to this very thing, there are two answers that one can provide in this. It's either, in fact, Chair, can I pause on this, because I would actually want the witness to answer this question. I would like a ruling. If you're saying I cannot ask it, then...
No, I've said ask the question.
Yes. The question then is, knowing what powers you had as an NDPP and what duties you had, and now the Act telling you that any person who contravenes with Section 32(1)(b) shall be guilty of an offense. The offense has already been indicated in the Act. Why did you not act in terms of the Act? And I'm not asking about a memorandum and all. The Act clearly says it's guilty of an offense. Why was there no offense put to the minister at the time? If she was, or I'm not saying she was interfering or anything, I do not know the facts. The minister is not here yet.
Thank you, Commissioners. I can say that the powers conferred on the NPA, or National Director of Public Prosecutions, includes the discretion to institute criminal proceedings or not to institute criminal proceedings. And this should not be taken out of context. We're dealing here with quite a number of important issues that required prosecutions. When we prosecute, there's what is called, strategic sequencing of issues that we put before the court. And I was not going to be distracted by issues which I thought at that time, because they were not going to run away. My main focus at the time was to go ahead and carry out the mandate of the NPA, which was to prosecute those who were denied amnesty or never even applied for amnesty. That was the focus at the time. Other issues would have been a deflection, a distraction, a deviation, and imagine the National Director also now in the process of the TRC mounting a prosecution against the National Commissioner, the DG of Justice. For me, those issues were not so burning because I knew how I was going to deal with those issues, because I was not going to succumb to that. And it would become a matter if I was, placed in a position where I could not proceed, for as long as I still exercised a discretion to prosecute those post-TRC cases. That was what was uppermost in my mind.
And you could still
You can
exercise.
disagree with that,
No,
but
no,
I'm talking about what I did or not do at the time.
No. In fact, I think we are on the same page. And therefore, what you're then saying, if I understand you correctly, you made a decision, say rightly or wrongly, that all these can be parked. You had the discretion as the NDPP. You exercised your discretion in relation to what these were. And you also just indicated, I'm just making sure that I understood your proposition. You also indicated that, well, you continued with your duties as an NDPP. Is that what I understand?
Yes.
Yes. Now, let's then just two last questions then on that very understanding that you continued with your duties as NDPP. It would in fact be four. So you have accepted that the ultimate responsibility of the NPA lies in the NDPP. That is what was corrected. And so do you accept that the buck stops with the NDPP when it comes to the NPA and the functioning of the NPA?
Yes, especially so far as prosecutorial decisions are concerned. But there's still structural dependence when it comes to the finances of the NPA, because it is the DG of Justice who's the accounting officer.
Yes. And then having accepted the above as you just indicated, and in fact you testified at length during your tenure from 2005 to sometime in September 2007, you accept then that as the NDPP during that period, 2005 to 2007, you bore the ultimate responsibility of prosecutions in the NPA.
That is correct.
And therefore you would accept that the ultimate responsibility, whether there was a failure or a prosecution, would then have been yours as the NDPP?
No, that would be a wrong statement to accept.
Mr. Pikoli, Advocate
No,
Pikoli,
no.
you just accepted that the NDPP bears the ultimate responsibility in relation to prosecutions and the running of the NPA. We've just established that. So on what basis do you then not accept that if you are responsible for what is good, you will also be, as an NDPP, be responsible for failures that occur during your tenure?
Council, sorry, Commissioners, Council stopped me when I was trying to explain. Because Council is talking about the failure to prosecute should be placed squarely on the shoulders of the NPA. Now, I was on the point of explaining the value chain. Prosecutions are dependent on investigations. Depends on the quality of the investigation, depends on the quality of the docket, what is contained in the docket, which would then enable the prosecutor to decide on whether to prosecute or not. It has been shown on a number of occasions here that there was a problem with investigators. It was explained, or I did allude to it, that the Chikane matter was a low-hanging fruit which did not require any investigations. So the fact that there might have been no prosecutions for a long time cannot be placed solely on the shoulders of the NPA because they needed investigators to bring matters to court. The starting point is investigations. And prosecutors would then decide on the basis of the quality of the docket
fully agree with you on that. So agreeing on that proposition of the value chain, you have now indicated there were issues about investigations.
That's correct.
You have indicated that a prosecutor cannot prosecute without a proper docket. And therefore, what we're here, you've now indicated these two things. At what point then of this value chain would any political interference come in? If you're accepting the issues are arising from dockets, they're arising from investigators, are arising from all these conspectors of issues, what part of these issues would then fall under what would have been termed interference?
Yes. Thank you, Commissioners. I think also I did explain this issue here. That I faced a charge in the Ginoa Commission for insisting on post-TRC prosecutions. Now, these charges were brought by government against me. Now, which government would charge a person for doing the right thing if they wanted the post-TRC prosecutions? Why would they charge me at the Ginoa Commission? Why was I put through so much stress and strain having to explain myself on the question of simple case which didn't require much, where ministers kept on asking me questions and I kept informing them my position. And these matters went on and on and on until I was suspended. And during my suspension, I had to face charges on post-TRC prosecutions. Simple reading of all the circumstances put together leave one with no option but to see the pattern that actually the NPA was being prevented. If we did not insist on the Chikane matter, and it was decided on, on the basis of a section 105 capital A, there would have been even no prosecution. At least we were able to secure a conviction, albeit unsatisfactory, because there is a criminal conviction of Flock, Van der Merwe, Otto, and others from Staden. That's a record that we have. And I was never given an opportunity to pursue other matters because I was suspended and never went back in September. All these issues were happening, there was a flood of activities in 2007, especially after we made the announcement that we were going to prosecute. I will leave it to the commissioners to make up their minds on the matter.
Well, one of the difficult things about this particular commission was that one of the rulings did say that the Ginoa Commission is not part of this. But be that as it may.
No, I would like to respond.
Well, that
I would
was
like
the
to
ruling,
respond. No.
unfortunately.
No.
Yes.
The issues here,
Yes.
affidavits that have been brought in, particularly mine, originate from the Ginoa Commission. Yes, of course, it's not about the Ginoa Commission now, yeah.
Yes.
But what happened at Ginoa cannot be ignored by this commission.
Ms. Nkloko, have we missed something? Is there a ruling on that from this commission?
That was, in fact, the application for the recusal was in relation to the Ginoa Commission. The DOJ's application for the recusal related to the Ginoa Commission.
Yes, but did we make a ruling?
Well, it was dismissed. And part of it, if we could go to it, and part of it was because it was deemed to not be relevant here. That was the ruling in this matter. That was the DOJ. In fact, I don't see Memoroka. That was their application. Ours was different. Theirs was in relation fully and squarely to the Ginoa Commission.
My recollection of evidence before this commission is that the evidence of Mr. Piccoli was led, and his lawyers put up extracts from the Ginoa Commission, including extracts of government submissions relating to charges against Mr. Piccoli in the Ginoa Commission. That is evidence before us. There was a subsequent request by lawyers for Advocate Similani to make the entire transcript of the Ginoa Commission available to this commission. That is as I understand matters.
So if we go to the ruling, in actual facts, this is before Commissioner Gabriel. This is before the evidence is laid. This is when the recusals were happening. And then subsequent to that, I think all the parties then accepted that the Ginoa, following the suspension, I just want to read this out. Paragraph 46, it says, the DOJ contended that Semenya SC was appointed as an assessor in and a legal advisor to the Ginoa Commission following the suspension of the former national director. However, as was pointed out by the evidence leaders, that involved an entirely separate issue about the fitness of the sole charge against the former NDP relating to the handling of the TRC case. That charge was in fact subsequently withdrawn by government at that inquiry. So there is a finding that has been made. And so my issue is the fact that it keeps on being brought back into this commission when the finding says the charge was in fact subsequently withdrawn by government at that inquiry.
Ms. Mtloko, you must be mistaken. There was no such ruling by this commission.
Chair, this is in fact your ruling on the recusal. It
Yes.
says, however, as pointed out by the evidence leaders,
Can you give me that ruling? When was the ruling made?
on the 4th of December,
Yes, can we have a copy of that ruling?
can,
Because we certainly do not remember making such a ruling.
well, I'm reading from it. It says, however, as pointed out by the evidence leaders, that involved an entirely separate issue about the fitness of the former NDPP to hold office. The sole charge against the former NDPP relating to the handling of the TRC cases. The charge was in fact subsequently withdrawn by government at the inquiry. Consequently, no substantive unfairness can conceivably flow from Semenya's SC's prior role in Ginoa inquiry. And my comment to the witness was, we cannot actually fully engage because it was clear in the ruling that the Ginoa Commission, and especially the charge that he keeps referring this commission to, is one of the things that we're told when this matter was being decided, that charge was withdrawn by government, and therefore, and the consequence is that it would not, unless we're opening up that discussion, and
Yes.
that's what I was
Miss-
hoping, we're not opening up that discussion, hence my comment.
Yes, Mr. Vani?
You know, Chair, we've exercised considerable patience. I've had to restrain myself before intervening. There is no such ruling. The fact that in your ruling you mentioned to that particular charge being withdrawn doesn't amount to a ruling on the admissibility of the Ginoa, of evidence put before the Ginoa Commission, which is squarely before this commission. We also find that my learned friend's questions are repetitious. This witness has answered those questions repeatedly, and I think it is time to draw these questions to a close, unless there's something fresh that my learned friend can put up.
I think, Chair, I was clear that my comment related to, I was hoping we're not opening up the Ginoa Commission.
Yes.
That is clear. And in actual fact, I think I need to respond to Mr. Vani. It's unfortunate that I have to. Mr. Vani subjected us to a whole day here with Advocate Similani, repeating questions. I am entitled, on behalf of the National Prosecuting Authority, who is, in fact, his client has alleged was interfered with, to ask the questions that I have asked. At no point, the witness has said, I've answered that question. And in instances where they have, I've said, can you then elaborate? There are certain questions that the witness answered without even saying that that has happened. In fact, if we are going to be dealing with patients, we all have been patient.
Yes.
Here.
Thank you, Mr.
So I do
Nhloko.
not, Chair, I think, Mr. Van, it should be stated, I do not appreciate the fact that he then goes and says what he has said. It's uncollegial on
Yes.
every conceivable manner.
Yes.
Sorry, Chair, can I just, I have a different
If-
problem.
Yes.
In relation to what Mr. Van, I'm not sure whether I heard him correctly, that the evidence in the Ginoa Commission is before this commission. Because what I understand is snippets of the Ginoa Commission.
Yes.
That was my recollection that Vani said that counsel or Advocate Similani had asked that the entire transcript of the Ginoa Commission be put before this commission. And my recollection is that Advocate Vani said that they would liaise with the secretary to establish a manner of sharing that information because it was quite an extensive document.
And that I know, there was no ruling from this House
Yes.
that transcript
Yes.
should be placed before the
Yes.
commission. I accept that we made that request on the basis of, transcripts that were being chopped from in the middle or we're not being given the full picture. We're just selective portions of the Ginoa report, and we say you can't do that. But as far as I know, my learned friend Mr. Vani has never told us that they've acquiesced to our request that the full transcript be placed, and that a ruling from this commission has now been placed so that people can talk about the
Yes.
Ginoa
There is no
Commission.
ruling, Mr. Masuku. I think your understanding is correct. Ms. Nhloko?
Thank you, Chair. And then just two last questions, Mr. Pukoli, on the minister and the NDPP. You accept that a minister, in terms of the Constitution and the NPA Act, has a role to play in the prosecution policy?
That I've already agreed to.
Yes. And that, in fact, then I'll ask the pointed question, that a minister insisting on being involved in a prosecution policy would not amount to political interference.
To put it correctly, the Constitution and the NPA Act define a role for the minister
Yes,
in the prosecution policy.
yes,
It says the policy is determined by the National Director of Public Prosecution with the concurrence
yes.
of the minister.
I think we agree on those principles, and those are, in fact, our questions. Chair, there is still the issue where Mr. Vani has put stuff on the record that is really unappreciated.
Yes. No. I take note of that, Ms. Nhloko. Mr. Vani?
May- Commissioners. Chair, Commissioners, may I say something short?
Yes.
Yes. I just don't want to leave that statement hanging. The role of the minister in the formulation of the prosecution policy. Because it is determined by the national director with the concurrence of the minister. And then there's a question of the final responsibility of the minister, which is outlined in section 33 of the act, what that final responsibility entails, which is limited to the minister asking any question, asking for reports, asking for any information on matters that the NPA is dealing with, organizing meetings with the minister and the directors. It was never meant to extend to the minister saying, now if I were to quote another case which is outside of this one, where there was a direct injunction which said that you must stop an investigation and the intended prosecution, that can't be seen as part of the responsibility of the Minister of Justice, even if there is a role that says the Minister of Justice exercises final responsibility. It does not extend to directing on prosecutorial decisions that are to be made by the NPA. I just wanted to make sure that we are on the same wavelength on that.
Thank you.
Chair, I think this just opens a very different can of worms.
Yes.
Because I do not know what case we're being referred to. This is not evidence that has been placed before. And in fact, there is now the Section 33.2 interpretation that has now been made. In fact, Section 33.2a is very broad in its very reading. Of course, that's a matter for argument that now the witness has brought. As I said, this creates a different can of worms because I don't know what case he's referring to. My question was
Yes.
very specific. The minister is involved in the prosecution, and we agree that the NDPP, with the concurrence of the minister, we agreed on the Constitution, we agreed on the NPA Act, we also agree on the minister's final responsibility in terms of Section 179. So I'm not quite certain where this example falls into the evidence at all.
May I insist, Counsel? Because the question of political interference comes from my own personal experience. And I'm the
Yes.
one who
But,
has
but
already made
Advocate Piccoli, you must confine yourself to the questions which have been put before you.
But Chair, I think it might be one of those, and I understand the day has gone. There's an example that has been made here.
Yes. What
ex-
example
that
did
example-
you say did not fall within the ambit of this commission, Advocate Piccoli?
And we need to know, Chair,
Mr. Chairperson.
who, when, and who said what to who and when. Those are important because then we might actually then say we will need to. There's a minister. The minister is here. We don't know what their impression of that will be. We need to know as the NPA as well when this example happened, who it happened with, and why it was never reported.
No. I'm sorry, Chair.
Yes.
You want a response
Yes.
on the matter? I mean, I thought it's a clear matter because I made the allegations based on my own interaction with the minister.
Which matter are you
minister?
referring to?
It's both this matter on the TRC matters and other matters which perhaps are not relevant for this
Can
constitution.
you
So,
confine ourselves to the matters before this commission? Which matter are you referring to?
you know, I was also at pains to say that, you know, what led to the Kalata group, for instance, I was approached by them to say, do I stand by what I said at the Ginoa Commission? That's why I'm talking of the relevance of the Ginoa Commission, because it originates from my affidavit that was submitted at the Ginoa Commission, where I made this assertion that there was political interference. And I agreed that, yes, well, I did say that I stand by what I said there, and I'm prepared to even depose to another affidavit in support of what they wanted to achieve, especially in the Nukutula Simelane matter, as well as in the Ahmed Timol matter.
Yes. Ms. Ntloko?
Chair, I'm still left none the wiser. Who said to him, stop this prosecution? And when did that happen? I'm still left none the wiser.
I'm sure, Council, you recall when I referred to the set of circumstances surrounding the TRC prosecutions, all the obstacles that were made, all the answers I had to give to the ministers about the implications of going ahead with the post-TRC prosecutions. It's on record. Those issues are here. They were traversed here. And I said, given the totality of circumstances, they only point in one direction and one direction only. And then I made it as an example, for instance, as to if there was willingness on the part of the executive authority to go ahead with the post-TRC prosecutions, then I would not have been charged for insisting on the post-TRC prosecutions, a charge which I faced, which was subsequently withdrawn when I started responding to that. That is a fact which cannot be ignored, which cannot be pushed under the carpet, because that's what happened at the Ginoa Commission.
Chair, I won't take this any further. I would think as the NPA will just argue we're not told who,
Yes.
when, and how. So at this
Yes.
particular point in time, we are left to then just make conclusions based on inferences in
Yes,
relation
you'll
to
take
the
it
alleged.
up in argument.
Yes. No, I want to put it so that if the witness wants to comment, that would be our argument. There hasn't been an instance where he says, I was told by X person to stop this prosecution on X date. It's all based on the inferences relating to his charges in the Ginoa Commission.
Advocate Piccoli?
If you allow me, Chair, I will not respond.
Yes. You have no response.
Thank you, Chair. That is.
Not that I don't have a response, but I will not respond.
Mr. Vani?
Chair, in respect of this cross-examination, it doesn't warrant any re-exam from us. We have no further questions.
Thank you. Yeah, we don't have the evidence leaders. We have the evidence leaders. Mr. Semenya?
Chairperson, I'm going to be asking the questions.
Yes, Mr. Soni.
Advocate Piccoli, we've listened to the interchanges between our learned friends and yourself and looked at your evidence in chief. Our main response to what you said in the evidence in chief remains, and that was dealing with the policy, the purposes of the policy, and so on. And I'm just trying to say that we are not going to traverse that part of your evidence again. I want to confine myself, though, to a couple of matters that have arisen since. One of the issues that has emerged over and over, both in your evidence in chief and your cross-examination, is the debate about what the role of the task team, interdepartmental task team, was. Now, can I ask you, and I think my learned friend, Mr. Masuku, may have referred you to PCJ 3. That's the minutes of the first TRC committee meeting on the 12th of October 2006. Now, before I get to that, you will recall that you were also referred to PCJ 1, which was your invitation to
Is it PTJ or PCJ?
PCJ.
PCJ.
Yes.
Yes, okay.
Those are the annexes to the affidavit of Commissioner Jacobs.
Yes.
Now, you will recall that PCJ 1 is your invitation to Commissioner Salebi to attend these meetings or to be part of this process. PCJ 1 is that invitation. I just want to put matters in the context where you say in paragraph 1 As you are aware, the prosecution policy with regard to criminal matters arising from conflicts of the past came into effect on the 1st of December 2006.
I think it's 2005.
Oh, I beg your pardon. I had marked mine, so it's just 2005, I'm sorry. And then in paragraph 2, you say, in terms of the guidelines, all such prosecutions will be conducted by the PCLU, which is located in my office. Then you go on to say that Dr. Ramaite will head and supervise the prosecution of TRC-related matters. Then in paragraph 4, you say, the PCLU will be assisted in the execution of its duties by a senior designated official of your department. And then thereafter, the first meeting was held on the 12th of October, and the minutes of that meeting are reflected in PCJ 3. And I ask you to look at those minutes, please. PCJ 3.
Do you want me to read them into the record?
No. I say, can I ask you to look at those minutes, please? And then paragraph 1 starts off by saying, you made the opening remarks. And I just want to read to you certain parts of the remarks that you made. In the third line, it is said, you indicated that the establishment of the committee is derived from the policy guidelines which were approved by Parliament in December 2005 on prosecution of all TRC matters. And then you say, then it is said that you attended a meeting with DGs from the South African Police Service, the NIA Justice, and a representative from the Office of the Presidency, where it was decided that a committee should be established. And then you say cases in possession of the PCLU and SAPS have to be identified, and an update on their status is also required. Now that obviously was going to be dealt with by the committee. Would I be correct, Advocate Pikoli?
Yes, the question of conducting an audit of
Yes.
those cases. Yes.
And we've been through the minutes. I don't think you were part of that process, but we've been through those minutes with both Commissioner Jacobs and partly with Mr. Ackerman. But the one I want to ask you about is, you then say, it said that SAPS has to provide investigating officers for all cases identified for prosecution. That was a requirement that had to be made, that this committee would fulfill. In other words, they would make those arrangements. Would I be correct?
That is correct.
Then you say,
Chairperson, I don't wish to interfere. I just want to point out that Mr. Pikoli has been testifying for more than 7 hours. I think we do need to establish from him whether he's willing to carry on. I know he's made the offer of coming back in the morning, but I suspect that the witness might wish to call it a day and come back afresh in the
Yes.
morning. Could we establish that from him, please?
Yes, I had already established that he was inclined to sit until 6 o'clock. Is that so, Advocate Pikoli?
Yes, Chair, that position still holds.
Yes.
Thank you, Chair.
and then the minutes go on to say the NDPP emphasized the fact that he will decide on each prosecution and not the committee. And that, I take it, is a matter that could not be placed in dispute in light of the fact that the Constitution, section 179.5, provided that that is a matter entirely in your hands, and it's a matter that you needed to, a power that you had to exercise independently.
That is correct, Commissioners.
Then it says, and this is the point I want to emphasize, the role of the committee will be to make recommendations to the NDPP on each case. And I take it that would be each TRC case. Would that be correct?
Yes.
Now, what was planned was that this committee, it has been called a task team, it's been called the interdepartmental task team, whatever it is called, this committee was to make recommendations to the NDPP on each case.
Yes, my understanding of...
Well,
of-
I have now, I'm just asking you, that's what's reflected in the minutes.
that is correct.
I want to ask you, what type of recommendations were envisaged that they would make to you, that the task team would make to you?
Perhaps it might not have been a right word to choose, because if you recall, it was more a question of having the investigators and placing information before the NPA, all available information that will assist the NPA in arriving at a decision.
Okay. So you say it was, but I mean, that was quoting you that the task team would make recommendations to you. These minutes appear to quote you.
Yes, not to the extent of saying prosecute on this matter, do not prosecute on this matter. It will be a question of having looked at all the matters that were placed before the prosecutors, following investigations which should have been conducted earlier on, and then put all that information. My understanding was not in the form of recommending a prosecution or not a prosecution.
So I'm going to ask you again. They were to make recommendations to you. That's what's envisaged, and that's what you had put to the committee at the first meeting.
Well, it could have, I would consider that, because then perhaps their understanding could have been that they were going to make recommendations on whether to prosecute or not to prosecute.
We've been through that. The question I want to ask you is, you've excluded recommendations on prosecution or not to prosecute.
Yeah.
The question I'm asking is a different one. They were nevertheless to make recommendations. The
Yes.
question I'm asking is, what type of recommendations were envisaged?
Well, I suppose it would have been a question of saying, for instance, if you prosecute on this matter, and given the threat assessment that would have been conducted by the National Security Agency at the time, then this would be the likely impact, which of course would have been an issue then for those involved in national security matters to try and mitigate. But it would not influence a decision to prosecute or not to prosecute.
Yes. Now, one of the things that would have you would have had to take into account for whatever purpose would be if, for example, the prosecution of a particular person would pose a threat to either regional or local, regional or national security. Would that be one of those recommendations?
Yes, of course, it will form
Yes.
part of those recommendations.
And we know, without going into particular details, that at the time of transition, there were what we called warlords who could incite people if decisions to prosecute would be taken and so on.
Yes, that is precise, Commissioners, yes. That is precisely why, for instance, I supported, a mechanism post the TRC process, which would also serve to address those matters, because the issues that our, democracy was still very fragile.
Now, it's quite clear, given the dispute especially, or the debate between you and Commissioner Selebi, that you regarded it as excluding the decision to prosecute. That would be your decision. Whatever the NIA said in respect of a particular threat, the decision on whether that threat could be mitigated or should be avoided altogether was your decision, because the Constitution had reposed that power in you.
Yes, it will be a question of one sticking to one's lane, because then my lane is on the decisions.
Absolutely, and you would have to take accountability for any adverse consequences that would flow if you ignored a relevant recommendation.
Which I would have expected that those charged with the responsibility of national security will take measures to mitigate.
Yes.
Should that realize.
But I'm just saying, at the end of the day, that's one type of recommendation. Would there be any other recommendations that were envisaged?
I don't. I don't know.
Okay. I would imagine that the presence of the NIA, for example, and the SAPS, which would also have its intelligence sources and so on, that would account for having them involved in giving a big picture from which you would on which you would base your decision.
Yes, Commissioners. Actually, it is the legal and national mandate of civilian intelligence to be responsible for counterintelligence in the country. Yes. Counterintelligence is meant to then neutralize or mitigate risk that can emanate. So it's a responsibility that lies elsewhere. That is correct.
Now, it's quite clear, given the letters exchanged between you and Mr. Selebi in relation to, in February 2007, that there was a difference of opinion. It was referred to as a misunderstanding or whatever it is, but there was a sharp difference of opinion between the two of you as to what the role of the committee is.
Yes, there was.
The question I want to ask you is this. That difference manifested itself in the exchange of letters on the 6th and 7th, and you've been through those letters. The letter that Commissioner Selebi writes on the 6th, the letter you respond to on the 6th, and thereafter you decide that this matter cannot be resolved, or you didn't see a way forward, you thought there was an impasse.
That is correct, Commissioners.
And your response was to say to Commissioner Selebi, I am now going to approach the minister.
That is correct, Commissioners.
Right. Because it was not a matter that could be resolved among the the heads of the different department or institutions?
Not that I didn't have a solution for it in terms of going ahead with the decision to prosecute, despite the differences.
Yes, no, I'm not talking about the decision to prosecute, but you approached the minister to assist in resolving the dispute.
That is correct.
Is that not quite ironical when one talks about political interference? You approach the head of one of the ministries to resolve an administrative dispute between the parties.
No, given the importance of this matter, which went beyond bureaucrats, because it was essentially a political issue. Therefore, the ministers are the politicians.
And you sought guidance from the minister on this issue.
I needed to know where she stood on this matter.
Oh, we know that that didn't end well, because eventually between the time that you wrote to the minister and the time you were suspended, that issue was never resolved.
Well, the resolution is the one that ended up in court on that particular matter, because remember, it emanated from one particular case, which was the Chikane matter.
No, I understand that. What I'm saying is the dispute about what role should the police play and what your powers are, that dispute was never resolved, except for the fact that you took the decision to prosecute.
Yes, in terms of people coming to a similar conclusion on who's supposed to be doing what.
Yes.
By the time I left, I was not aware of it having been resolved.
Now, let me ask you a more general question. You became the NDPP in early 2005.
On the 1st of February, to be precise.
You were then suspended in September 2007.
That is correct.
In your period as NDPP, as I understand it, there was just one case that was prosecuted.
Yes, that is correct.
Now, that on any basis, given the need for bringing these matters to a close for many families who had waited for decades to know what really happened, because that was part of what the prosecutions were going to be about. You must accept that that's an unacceptable success rate.
I do accept that it is unacceptable.
Now, one of the questions that was asked, and I think it's by my known friend for the NPA, she said to you that you, on behalf of the NPA, on behalf of the NPA, must take responsibility. I'm not going there. I am saying it's quite clear from the disputes that arose that there was an institutional problem between the NDPP and the South African Police Service.
Clearly there was.
Yes. And that, we can say, played a major role in the poor record that we all know about now.
Yes, that is correct, but there is an explanation for that.
No,
Yes.
I'm just looking at
Yeah.
at an analysis of who the role players, the institutional role players are.
That is correct.
Are there any other factors that contributed to this poor record?
Pardon?
Are there any other factors that contributed to this poor record?
Well, for me, the real critical and relevant factor was the non-availability of investigators, because SABs were not playing ball when it came to that. The DSO itself was not playing ball. There was tension between the PCLU and the DSO, and all this time we were trying to fix those problems in terms of availing prosecutors, in terms of availing investigators.
So that you put as the central factor.
I put it as what?
The central factor for
Yes,
the poor record.
it's very critical.
Now, and I don't want us to debate this, Mr. Pikuli, because evidence on this has already been given by both Commissioner Jacobs and Mr. Ackerman as to the toing and froing as to whether investigators were offered or not offered. I just want to put this to you, though. As I understand it, there were communications made between Mr. Ackerman on the one hand and the South African Police Service on the other, and then Mr. Ackerman and then the DSO on the other hand, and then when certain offers were made by the DSO, there was then a further approach to the SAPS, and those offers were made by the SAPS thereafter. I'm not saying the offers were accepted and so on. I'm saying that is the evidence that has been placed before this commission. So effectively, the question really is, was it the NPA or the police that should be held responsible or accountable for this poor record? Would that be a fair assessment?
Is the question,
I
is it the SABs or the NPA that should be
I
held?
say that, and I'm not asking you to resolve that dispute. I'm saying it would be based on the evidence on these matters. It would be one of those two institutions.
Yes, because they are the primary role players.
I just want to put one further question to you, and I'd like your comment on it. In his book on, and I think it's things that shouldn't be written or whatever it is, Reverend Chikane says that one of the factors that led to this regrettable, unfortunate, and one may say almost tragic record that exists in relation to the prosecution of TRC matters is the fact that there was no appetite to prosecute, that things from the past should be left. I'm just putting that as a proposition to you so you can comment on it.
Well, thank you, Commissioners. Well, certainly on the part of the NPA, there was no lack of appetite to prosecute.
Sure, we have no further questions on behalf.
Thank you, Advocate Sonny. Mr. Vani, I see we are almost at 6 o'clock for your re-examination. I'm alive to the fact that Advocate Pikoli had agreed to accommodate us until 6 o'clock.
African time.
Chairperson, I undertake, I see it's 3 minutes to 6. I undertake to finish by 6.
Thank you.
I only have one question, Chairperson.
Yes.
Advocate Pikoli, just to follow up on my learned friend, Mr. Sony, where he asks, was it the NPA or the SAPs who were responsible? And you've responded firmly that certainly there was plenty appetite on the part of the NPA to investigate, but one of the critical factors was the lack of investigators. Now, this commission has to get to the bottom of that question, amongst others. Now, it has been your evidence that SAPS, and in particular the then National Commissioner of the SAPS, the late Jackie Salebi, that he had indicated in uncertain terms that pursuing cases against the former apartheid security officers would then give rise to calls for cases to be brought against the ANC. Now, looking back with the benefit of hindsight, question one is, was it merely coincidence that investigators could not be supplied in most cases to the TRC matters? And then secondly,
What's the first question? Sorry,
yes, please go ahead, yeah.
No, what's the first question?
The first question is, was it merely coincidental that the TRC cases always suffered from a lack of investigative capacity, notwithstanding the best efforts of the task team and others? Let me ask you that question first.
No, my position is that it was not a coincidence.
And then secondly, what explains that? And that's why I put to you the sentiments that you heard from Commissioner Salebi and his opposition to matters being pursued against former police officers, because it would then give rise to calls for cases against the ANC. In your view, do you think that ultimately explains why there was a reluctance to provide investigators for the cases you wish to pursue?
Yes, because the same fear was expressed by ministers in my interaction with the ministers on the question of the prosecution of Flock and Fona Mervin, that it might lead to pressure being brought to also prosecute the 37 ANC members who were denied amnesty, which thing again was explained that the matter was looked at by Mr. Nuka. And the matter, as far as Mr. Nuka was there, it was closed, and when I was there, it was never reopened as far as I know. So this was then used, as a threat.
No further questions, Chairperson.
Thank you.
Chair.
Yes.
Mr. Piccoli, one aspect, the removal of a prosecutor, particularly as senior as Advocate Ackerman, does not have to be taken lightly. Now, what I want to know from you, did Advocate Similani, as mandated by the Directors General, place any memorandum, any minutes, giving reasons why Mr. Ackerman had to be removed from his mandated work that he was appointed for?
Thanks, Commissioner. No, there was no written memorandum other than the nature of the discussions.
Oral?
Yes, as far as I know, the oral discussions. I don't recall receiving any written memorandum requesting such.
Okay, thank you. Thank you, Chair.
Thank you. Advocate Piccoli, we thank you again for having agreed to give evidence before this commission, and thank you for your patience in having agreed to accommodate us until 6 o'clock tonight. You are now excused as a witness and have a safe trip.
To Pretoria.
You are not
Thank you,
going
Chair.
to Cape
Thank you,
Town.
Chair. Thank you, Chair. And thank
Yes.
you, Commissioners.
These proceedings are adjourned until tomorrow at 10 o'clock. I think it's going to be doable from share. We are adjourned.
daughter's wedding is in a month. I don't want us to look like Beauty and the Beef.
Darling, relax. We have plenty of time.